6 and 2, please. Yes, please.
Respondent 6, please. 6, 2, and 6. 350 Central Park West versus DHCR.
Appellant 5 and 2, Your Honor.
And respondent for the 350 CPW Tenants Association, 2 minutes, Your Honor.
Tenants Association, 2 minutes. 5 minutes. So 5, 2, and 5. As Sheena, Gorus versus New York City Housing Authority.
Appellant requests 5 and 2.
Respondent requests 5.
5, 2, and 5. The fifth case, I am recused, Coresight versus Njar. Who's your honor?
I'm here for respondent, Your Honor.
I'm here for appellant, Your Honor.
Okay, Appellate.
5 and
5 minutes.
5 and 2.
5 and 2, got it.
6, Your Honor.
5, 2, and 5. People versus Rob and Perkins.
Appellant request 4 on direct, 1 in rebuttal.
4 and 1.
The people request 4, Your Honor.
4, 1, and 4. Harleysville Insurance versus United Fire.
Appellant, Your Honor, 5 and 2.
Respondent 5. 5, 2, and 5. Consolidated appeals on Coresight. Who's your on Coresight?
Appellant.
Well, rather than appellant, which appellant? Tellers, okay, yes. Okay, how much time do you want, John?
10 and 5.
I will give you 8 and 2, Alex. And owner? Who's the owner?
Letitia Thompson Morrison on here.
You have an appeal, so how much time do you want?
On the appeal,
We're gonna hear everything together. You are completely included.
5 and 30.
Okay, I'm giving you 8 and 2.
8 and 2.
Okay, and then finally, the plaintiff.
6.
You got 6. So it's 8-2, 8-2, and 6. People versus Newsom?
Appellant requests 6 and 2, Your Honor.
You want 5? You don't want 6? Very good. Knoll versus 336?
Appellant request 3 and 1, Your Honor.
Respondent requests 3, Your Honor.
3, 1, and 3. Fox versus Barrows Auto Shop.
Appellant 5 and 1.
5 and 1. 3 minutes. You got it. Sakia versus Brookfield Properties.
Respondent ABM and Brookfield request 5.
Respondent Harvard, maintenance, 5, please.
6255. First case up, People versus Edwards. Anytime you're ready, counsel.
Good afternoon, Your Honors. Respondent concedes that the prosecution here suppressed Brady information. The only question is whether there's a reasonable possibility that but for the prosecution's error, the verdict would have been different. It would have been for 2 different reasons. It would have been for 2 different reasons. The first is the prosecution's case rested almost entirely on the testimony of the teenage complainant, Zaire, who had a history of bad blood with my client, Jason, and who had enormous credibility problems, as the trial court recognized. The introduction of an objective adult witness who would have testified that the shooter ran in a different direction than Jason.
Counsel, did trial counsel request an adjournment in this bench trial to be able to do some investigation to find that person?
No, Your Honor, but an adjournment would not have cured the prejudice here, and that is made absolutely clear by the Court of Appeals case in People v. Wrong Hay. The people have an obligation to provide meaningful access to the witness. When the prosecution failed to provide this information for over 2 years and then when they did, provided only a non-working number for the witness, that does not satisfy their obligation under Brady. And in
Didn't they also give the telephone number to where the witness worked?
they gave the address to where the witness then worked 2 years ago, and defense counsel said, I have tried, I can't get in touch with him in any way, shape, or form. The representation is this information is no longer good. To continue with the first prejudice point, I'm sorry. When you have a witness who would have been objective, who would have been an adult,
Counsel, the witness would have testified essentially to the description that was visible on the surveillance video that trial counsel had at the inception of the trial, correct?
well, no, it's not just the description. I think the key point is the direction that the shooter ran, which
But the
undermined.
description was the same, right?
I don't think so, Your Honor. No, there's a description of the pants, which I think you're referring to, but which way the shooter runs is different than what's on the video.
And was that in the DD5, for example?
It is in the DD5,
Okay.
correct?
So a remedy that was suggested was to allow the document to come in.
Here's why.
Let me finish.
I'm sorry. Your Honor.
You cross-examined, or the trial counsel cross-examined on that, and then didn't he or she make a strategic determination not to put it into evidence?
That's precisely right, Your Honor, but the DD5 is, again, not a sufficient remedy here for 3 different reasons. The first is, as the prosecutor recognized, the DD5 was equivocal in light of the 911 call. They cancel each other out. A live witness saying, testifying under oath, the shooter ran in a different direction, that's a very, very different flavor of evidence. The second problem is the DD5 doesn't cure the wrong hay problem. It doesn't cure the meaningful access to the witness that was denied here. So that's a second reason. The third reason is the prosecution takes that opportunity, and we set this out in our brief, to get in front of the fact finder immensely prejudicial information, the statements in the Queen for a Day, which the defense counsel did not open the door to, would never have otherwise been introduced. For all 3 of those reasons, the solution proposed by the prosecution, that DD5, is an illusory solution.
What solution was proposed by defense counsel?
Defense counsel is a little bit stymied because of where the prosecution left him. He said, I don't really know what to do here. But that's
How about a mistrial? Why not ask for a mistrial under the circumstances? This is a trial before a judge, correct? I mean, as I recall, it's not the jury's not impaneled. Ask for a mistrial.
I think that would have cured the prejudice, Your Honor. But I think it is a mistake to put that on defense counsel for 2 reasons. It's not on defense counsel to get the people out of the hole they dug for themselves. And certainly, if this court reverses, new trial counsel can make that suggestion. It's an extreme remedy, but obviously the trial court does have that discretion. And the problem with Brady, and this is why the Court of Appeals has said that these types of errors are seldom, if ever, excusable, is that the only remedy becomes a very, very large one.
But the remedy, you just conceded that the proper remedy was to ask for a mistrial, and I can understand why, because you have a phone number from 2 years ago, not enough time to do an investigation.
I'll try to answer it in a similar way, Your Honor. I think once defense counsel says, Your Honor, there's a problem here, it is also on the court to conduct an inquiry and come up with a meaningful full remedy. I don't think
It's up to the court to tell defense counsel what to request as a remedy?
I think it is on the prosecution not to make this violation in the first place. I think it is on the court to conduct some inquiry, not to just sit there, and to try to figure out.
Is that what the cases say, though? Is that what the cases say, that the court at that point has an independent obligation?
Well, certainly the Second Circuit in Lica vor Portuando suggests that. There's no remedy suggested there, and yet the Second Circuit decides the habeas in the defendant's favor. I want to just step back one sec for the big picture here. The Court of Appeals has made clear that Brady, much like the exclusionary rule, is intended to deter bad behavior by prosecutors. To insist that the defense counsel needed to make more of a request for a remedy creates very bad incentives. It allows the prosecution to withhold evidence, come back 2 years later, say, whoops, our bad, defense counsel, what do you want to do about it? I don't think that's the right way to go here.
Fair enough. Thank you, counsel.
Thank you very much, Your Honors.
May it please the court, Alex King for the people. Defendant's Brady claim is unpreserved. He was offered relief that was apparently satisfactory.
Counsel, can we pick up the thread about the Queen for a Day comment made by the prosecutor at trial? How did anybody open the door for that comment?
What the prosecutor was doing here is to clarify what he would potentially want to introduce in response if a defendant was to use the DD-5 form. In fact, the trial court thanked him for his clarity. There's nothing improper about disclosing to
The trial court was the finder of fact, right?
Yes.
Okay, the Queen for a Day comment is extremely prejudicial. Wouldn't you concede?
No, I would not. The trial court, as the Court of Appeals has repeatedly said, is uniquely capable of making an objective determination based upon appropriate legal criteria, despite awareness of facts which cannot properly be relied upon. In addition, the court repeatedly told defendant that it would be aware, if there was a bench trial, it would be aware of matters that a jury would not be aware of. In fact, as to this issue specifically, as to these Queen for a Day statements specifically, so there was nothing improper, nothing prejudicial about disclosing.
Well, it's not that it was not improper. What you're saying is that the trial court could have excluded that from its calculus in looking at the case, right?
Yes, that's correct. As a legal matter, it certainly could have.
But it shouldn't have been stated.
No, I don't agree. It was perfectly proper for the prosecutor to state this.
Okay.
As to prejudice, defendant could have used these materials on cross-examination if he had wished to do so.
Well, they used them on cross, didn't they?
No, the defense
all?
counsel did not seek to use the DD-5 on cross.
No.
Beyond that, all that defendant offers is the entirely speculative suggestion that if the materials had been disclosed earlier, maybe he would have uncovered some kind of helpful lead.
Well, I think what counsel is arguing seems pretty obvious, is that had you turned them over 2 years ago, we would have tracked down the phone number and got the witness and had a live witness on the stand to maybe raise some issue with respect to the direction. That seems to be the focus now, at least on appeal.
Perhaps, but that is speculation. Defendants often raise these vague speculation claims as to Brady information, and they rarely.
You concede this was Brady information, though, correct?
The people are contesting the prejudice prong of the Brady analysis here.
Anything else?
No.
Thank you.
Thank you.
Counsel, would defense agree to Queen for the Day if they could bring it up in court?
No, absolutely not, Your Honor. And here's how we know that the Queen for a Day statements would never have come in and that this was opportunistic behavior by the prosecution. They didn't come in at trial. Defense counsel opens, practically the first words out of his mouth are to suggest that there could have been another shooter. That's trial transcript, page 24. That didn't open the door to the Queen for a Day. Okay, I'll move on.
Counsel, do you concede, though, that a judge, as a trier of fact, can disregard comments that are not appropriate, right?
I think that we maintain that fiction. I think it is very, very, very hard to unring that bell, and we shouldn't incentivize bad behaviors by prosecutors nonetheless, either way. I think there is a difference between opening the door on the defense counsel's side and the prosecution pushing open a closed door. I wanted to address speculation as well. People v. Wrong Hay, I direct the court to. There is the Court of Appeals orders a new trial because of the lost opportunity that was the defense lost the opportunity to explore this witness. There is no inquiry into what additional facts defense counsel might have discovered, what additional theories it could have led to. For the prosecution to come back here in this court to say, well, we don't know, it's speculative, what could have found out, That's because of the original Brady violation. And to allow the prosecution to do that, to suppress evidence and then come back and say, who knows what was out there? Too bad, so sad. This is exactly what the Brady Doctrine is supposed to prevent.
Thank you,
all for me,
counsel.
Your Honor.
Thank you both.
Thank you.
350 Central Park West versus DHCR.
Good afternoon, Your Honor.
One second.
Sorry.
You may proceed.
Good afternoon, Your Honors. James Schwartz, Cucker Marino, for Appellant 350 Central Park West. As the court, I'm sure, is aware, this is a case about the potential replacement of manual elevator operators in elevators that have already been converted to automatic. The issue that the court faces, and I know we're appealing from an administrative decision, but there are infirmities in the decision. Number one, that the administrative agency did not follow its own precedent. And as this court has said in the 25th Avenue case, when an attack is made on an administrative agency, DHCR, for not following its own precedent, the court takes a look at what the DHCR precedent is.
No, you're absolutely right, counsel. There's no question about that. But the question is, are the facts the same? And here it seems there was not an adequate substitute made, whereas in those other cases there were substitutes made for
Judge Moulton,
the services that were
let me
stopped.
suggest the following to you, Justice Moulton. The 11 Riverside Drive case, which is cited and contained in the record on appeal at pages 534 to 537, is virtually identical.
But let's talk about the facts here. My understanding here is that the elevator operators, to some extent, part of their services is to provide vertical security. So under the proposal, essentially it's a 3-for-1 substitution. And did DHCR get it wrong to say that that was a decrease of security and services?
Well, yes, because the elevator operators are in the elevators. The proposal is to replace the elevator operator with a lobby person. And the lobby person...
is it 3 or 4 elevator people with a single lobby person? 3, right?
So 3-for-1.
It's 3, not 4. But in the 11 Riverside Drive case, it was 4 elevator operators for 2 lobby persons. It's not that radically
But
different.
it's different, right?
Excuse me?
It's different. It's different. It's not the same.
Well, the math says that it's different. It's not the same, but the concept, it's very, very close. And
But also in Riverside, that case, didn't they install security cameras? You already had security cameras.
we have security cameras. We certainly do have security cameras present already, and the new person would be able to look at the security cameras. Now, I'll raise. I'll raise
part of counsel, part of what the tenants object to the replacement of these elevator operators is that somehow they also make them feel safe as they're walking to their apartments, because they can look down the hall and make sure that people get to wherever they're going safely. Do your cameras, are they in the hallways? Are they in the stairwells?
My understanding is that they are not, but the same issue in the 11 Riverside Drive case took place. The rent administrator said you have to install cameras in places such as that. And on the petition for administrative review, the camera requirement was reduced to the lobby and the elevators. And we have that here already. I do think that there's one more point.
Counsel, you want to replace 3 elevator operators with 1 hall monitor from 4 p.m. to 12 a.m., correct?
4 p.m. to 12 a.m., that's correct.
And that hall monitor is going to be in a room looking at cameras?
There's a doorman that does that, and the hall monitor can do that. The hall monitor can do that as well. It's an additional security
Who's
person.
providing vertical security
I'm
to the
sorry, I did not hear
tenants
you, Your
in
Honor.
the elevators?
Who is providing security in the elevators? Well, right now, it's the
The elevator
elevator
operator.
operators, but You have security. You'll have security cameras that are in there, and you will also have an extra person in the building who is able to go throughout the building, who's not.
But it's not an extra person. It's less. It's not more. I know you characterize it as providing more security, but you're doing a swap of 3 for 1.
Your Honor, the issue is not whether you have more or fewer people. This court and the Court of Appeals has decided in the Howard Carroll matter in the late 1970s, there was a reduction in the number of cleaning people in a building. 20 became many fewer. And the court held that as long as the function was still being served, it was okay, no matter that there were fewer people doing it. I also want to raise one more point, and that's
Finish your point.
Thank you. The standard of review. It is completely unclear whether DHCR applied the strict standard of review required under rent stabilization, or whether it should have been a different standard of review, the adequate substitute test. It's not clear whether in using
Did you raise that below?
It was not, it was.
Is there an issue with preservation? Why don't you answer that question? Thank you.
The answer is no, Your Honor. It's a pure question of law. The facts are contained in the record, and if it had been raised below, the issue could not have been avoided.
Okay, thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. My name is Dawn Ivy Schindelman, and I represent the respondent, New York State DHCR, in this proceeding. The lower court properly upheld DHCR's par order, which...
Can you address your adversary's point that you folks aren't being consistent with your precedent in this area?
Yes, it's DHCR's position that we are being consistent. They have the adequate substitute test, and we found that the owner did not propose an adequate substitute to replace the...
Oh, you heard what counsel said. There'll be more security down below. People in the operator will be monitoring the building, going different places. Isn't that adequate?
No, I agree with the panel's earlier comments. You're taking 3 elevator operators, and he's proposing to replace them with 1 lobby person to observe cameras, which are already in place. So they're not really adding anything. Like you said, it's not more, it's less.
Where are these cameras in place? Where are they?
I believe they are in the elevators and the lobby and the building entrance. They're not in the hallways or the stairwells or the landings, and that's what the tenants pointed out in their submissions to DHCR, and DHCR found that to be a concern.
Their argument seems to be, we've already done everything that we could have done. We have cameras in place, we have a door person in place, we have a hall monitor in place, and there's really no need for the elevator operators. These elevators are automatic. There's a camera in the elevator. What more do you want from us?
It's not just the mere operation of the elevators. They're automatic, so you don't need someone to press a button. I believe the tenants established in their submissions to DHCR, it's the sense of security that these live elevator operators provide during the peak hours of 4 p.m. to 12 a.m. And the tenants explain that can't be adequately replicated by...
Counsel, should there have been a revisitation of the record, because a lot of the affidavits from the tenants came during the pandemic, and a lot of them, I think most of them, cited the fact that delivery services had increased a great deal during the pandemic. And so that was a time-specific concern of the tenants, which is now gladly not with us anymore. Is that something, does that undermine?
No, I respectfully disagree, Your Honor. At the advent of the COVID pandemic, it changed consumer patterns where residents and everyone were ordering more online and also ordering groceries and restaurant meals to be delivered, and it may have tapered off a little, but I think the flow of foot traffic is still very present all around.
Counsels, didn't the tenants also say that they felt more secure with the elevator operators who could stick their head out to make sure that there weren't any intruders waiting for them?
Absolutely, Your Honor. Many of the tenants pointed out that the elevator operators poke their head out of the elevator and wait and watch for them to safely enter their apartments. And if there is a delivery person, they hold the door and wait for that delivery person to come back into the elevator and make sure that they promptly exit the building.
If the 3 operators were to be removed, how could we deal with a possible intruder on the hallway? Are there cameras there?
No, there are no, as the owner's attorney confirmed, there are no cameras in the hallways. It's only the lobby, I believe, and the elevators themselves.
Can you, the 2003 application that they made to basically remove the elevator operators then, they seem to suggest that your decision denying their application then was simply because they did not agree to substituting one of them and making them an additional hall monitor. But now they're willing to do that. Can you address that?
Yes, I can, Your Honor. The 2003 application, I believe the owner merely suggested that they were entertaining the idea of possibly substituting with a hallway person, but they didn't say that they would do it. So they never formally introduced that as that was exactly what they were going to do, whereas in 2017, it was clear in the proposal, they said, we will substitute the 3 for the 1.
So wouldn't that remediate whatever inadequacies there were back in 2003?
No, it would not, because in 2003, they didn't propose any substitute. Here, they proposed a substitute, the 1 hall person, except DHCR fully evaluated all the evidence and found that it was an inadequate substitute. Therefore, they weren't eligible to have the modification of services application approved. It's correctly denied.
I want you to address one more issue, because you're not going to have another opportunity to, and that's what your adversary says, is that you applied the incorrect standard. Is that something we can consider on this appeal?
I don't believe so, Your Honor, because as you pointed out and my adversary confirmed, it was not raised below, so it's not ripe for judicial review. But even if it was, I think it's clear in the RA's order and the PAR order, and it explicitly states in the language there that the adequate substitute test was used, that the owner's proposed modification was not an adequate substitute.
Thank you, counsel.
Thank you.
Please proceed.
Good afternoon, Your Honors. William Gribben, representing the 350 Central Park West Tenants Association. So 60 tenants submitted statements to the Division of Housing and Community Renewal. They're in the best position to actually know what the elevator operators do. And as the court has observed,
How do you respond to my colleague's point that times have changed?
fortunately they do, but they haven't changed to, I know that the rent administrator mentioned COVID. That's when it was going on. I guess everybody was thinking about it. But that doesn't, the fact that COVID is dissipated and maybe some of that reason is not as forefront as it was, doesn't take away the fact that the elevator operators, as stated by 60 tenants, and the court observed, they provide security within the elevator itself. A camera does no good whatsoever if somebody is saying, stand there, don't move.
In the description of the job function of the elevator operator, is security mentioned?
Your Honor, I don't know if it's mentioned. I haven't looked at the job description that the owner gives them, but we know what they do. They're in the elevators, which is the best type of security you could have in an elevator, having a live person there. It's random vertical security, which again, I think any security expert will tell you that that's the height of security. When an intruder has no idea whether or not somebody is stationed in a place and they could avoid it, the elevator operator is vertical security. And as the court has pointed out, there's also hallway security, because the elevator operators will watch somebody walk to their apartment to make sure that everything is okay.
Do they ever leave the elevator and walk the hallways or walk the stairwells to make sure that there's no intruder there?
Again, Your Honor, I don't know. I haven't seen the job description, but again, I mean, under required services and essential services, it's not it's not based upon what an owner might have told a building employee to do.
Counsel,
It's actually
even if they're not having a security in their job description, their very presence serves as a deterrence. Is that not what the tenants are saying?
Yeah, if I heard Your Honor correctly, Your Honor. Yeah, I mean, it's obviously, it's the major deterrence. Anybody who knows that when you walk into an elevator and there's a person standing there and says, hello, Mr. or Mrs. So-and-so, you're going to feel safe. You walk into an elevator and somebody comes in after you and you don't know who it is, that's a detriment in the security that an elevator operator provides to people. And I just want to end with this. We've all talked about what the elevator operators do. But what the owner says they do is, quote, and he says it over and over, merely push a button. So I think that says a lot about what the owner thinks about what the elevator operators provide to the people at 350 Central Park West. Thank you, Your Honors.
Thank you.
Your Honor, on the main argument, I had suggested that we had not raised it below. I made a mistake in saying that. We did raise it below at par. And it's quoted in what we said is quoted in my brief at page 8. And so there is a basis to look at it even irrespective of the exception that I had spoken about. The tenants who responded, there were 60 who responded. 10 of them said they had no objection whatever. And many of the other ones very often checked a box that said I object, or objected rather tepidly. There were some who did it. There were some, I don't deny it, who objected. But this is an intensely factual question. And in terms of this, when we made the application, take a look at page 7 of my brief, footnote 5. Before the rent administrator, those responses from the tenants were not furnished to us. They were not furnished to us until we went to par. And the result of this, what happened at the DHCR, what happened before the rent administrator, given all the cases where the landlord has been allowed to replace elevator operators in automatic situations with lobby people, is that we didn't have an opportunity to respond before the rent administrator. I will grant that by the time we got to par, we did have the opportunity to respond, but the result could have been different had we been furnished with those items.
Thank you.
Thank you very much, Your Honors.
Gorus versus New York City Housing Authority.
Good afternoon. May it please the court. Patrick Lawless for the defendant appellant, New York City Housing Authority. NYCHA's motion for summary judgment should have been granted. There's no evidence of foreseeability in this.
Why do you say, I mean, no question that the guy had issues, serious issues. There were noise complaints, there was aggressive banging on walls, and why isn't that sufficient to put you on notice? Or why doesn't that make it foreseeable?
Well, the standard for foreseeability is that the criminal conduct at issue, which in this case was the violent assault, has to be reasonably predictable based upon prior similar criminal activity at that location. Here, there's no evidence of any criminal activity. Mr. Gerard didn't have a criminal record prior to this incident.
Weren't the police called to the apartment to complain? Someone complained about fighting in the apartment and the police responded?
There were noise complaints. We don't know what took place in there, but there were never any criminal charges filed. All that we have is complaints about arguing and music coming from inside the apartment. There's no evidence
about violent behavior in the apartment were made, correct?
Again, it was no one knows what took place inside the apartment. It was arguing and loud music coming from inside the
Banging
apartment.
walls, right? Banging walls?
Banging on the walls.
And cursing?
I'm sorry?
Cursing?
And cursing. But the plaintiff and every single witness in this record all stated that Mr. Gerard never made any threats to them, never acted aggressively, never made any committed any threatening conduct prior to this incident.
And counsel, this is not a case, is it, where there was a great deal of illegal activity going on in the building, or there's nothing in the record about that, right?
No.
It might give some notice of an environment of violence.
Absolutely not. And to sort of underscore that point, there's a case that the plaintiff cites in his brief. It's called Neal. It's a case from this court, and that shows the distinction. In the Neal case, you had an assault on the plaintiff from a tenant. Now, prior to that assault, the plaintiff had been punched, and his mother's apartment's window had been smashed after the plaintiff and his mother had made complaints that the assailant was engaged in illegal drug activity in the hallway, and there had been prior threats against the plaintiff for making those complaints. In this case, again, there's not a single
Counsel, what about
shred of evidence.
What about Miss Maria Cruz, who indicated and complained that she was afraid that Girardi might hit her?
Again, this is all, the complaints are based upon their own subjective impressions. There's no objective evidence of any violent or threatening conduct. Maria Cruz's own son said he interacted with Mr. Gerard, and he seemed like a normal person.
But what about
prior
what
to this
she
incident.
said about her interaction?
She said because she heard
Counsel, I was still talking.
she heard
Counsel, I was
loud
still
noises coming
Excuse
from the
me.
apartment.
We can't talk at the same time.
I'm sorry.
Right, I need to finish my question before you continue talking. So she indicated that based on her interaction with him, that she was afraid of her safety.
But she also admitted she'd never been threatened by anybody inside that apartment. She based that upon her own subjective feeling, based upon the loud noises and music coming from that apartment, but no one from that apartment had ever threatened her. And as a matter of fact, there were instances where mail had been misdelivered and it was turned over to her without any incident. So she never had any threatening or any interactions to feel threatened by from her next door neighbors. She just said subjectively she felt threatened because of loud noises coming from that apartment. It's the same thing with.
Why isn't that sufficient?
I'm sorry?
Why isn't her subjective feelings, or at least how she sees him portraying towards her, sufficient?
I don't think it's sufficient based upon the legal standard, which is, and again, the legal standard requires prior criminal activity. So she's relying on her own subjective feelings based upon loud noises coming from the apartment, even though there's no threatening conduct. And the plaintiff himself even admitted numerous interactions with Mr. Gerard. Never once was he threatened, and he based it on his own, again, subjective and vague impressions of
Thank you. Why don't you hold the rest for reply?
Thank you.
Good afternoon, may it please the court. We're here to
wanna-
determine credibility and.
State your appearance for the
Oh,
record.
Mark Walsh, Drossos and Jaros on behalf of the plaintiff respondent.
So the question I have for you is, what was the likelihood that Gerard's clearly rude, obnoxious, inappropriate behavior would escalate to the violence that occurred, unfortunately, in this case?
I can't quantify that as far as some percentage. I mean, in hindsight, we could say 100%. But I would say from
The analysis foreseeability, right? It has to
correct,
be
it's foreseeability, which is you know,
how
as a matter of law, I don't know that I could quantify.
So how is it foreseeable based on this conduct, noise complaints, banging on walls, loud arguments, that he would commit a criminal act
The answer is twofold. I think originally, if you look at it, if we're not playing Monday morning quarterback and we're looking at it from the perspective of NYCHA, who at the time didn't know that he was living there and still had the husband on the lease, and the Miss Acevedo testified she was unaware of when he moved out, notwithstanding the order of protection that had been issued against him. That order of protection was for domestic abuse.
That was for the husband. That was for the husband.
Yeah, right.
But what about Gerard? Was there any?
NYCHA didn't know that Gerard was living there at the time. As far as they're concerned, the husband was living there and he was committing acts of domestic abuse, which is a history of violent crimes.
But now we're dealing with Gerard. Now we're dealing with Gerard.
And the foreseeability of his conduct, right? So I know that you said you don't want to do Monday night quarterbacking, but you do need to address the legal issue of foreseeability.
Right, but what I'm saying is at the time, NYCHA didn't know who was in the apartment. So how could they distinguish the foreseeability?
So then how is the act, based on what you're saying, how is Gerard's act even foreseeable if they don't even know who he is?
Well, because they don't know the identity of the individual, but they know the events that are occurring inside the apartment.
So noise, right? Okay, so let's talk about examples. Noise, loud music, banging on walls, right? Your adversary says that the standard here is criminal conduct must be reasonably predictable based on prior occurrences of same or similar criminal activity. How do you connect the two?
If I recall correctly in his brief, the citations provided for that precedent are both Second Department decisions, and they're not recent. They're from the 1990s, I believe. If we want to talk about foreseeability and the standard for summary judgment, I would look towards actually a more recent decision by the Court of Appeals in Scurry v. NYCHA, where foreseeability and proximate cause were an issue, and they kind of discussed how they intertwined, and they said that foreseeability issues are often matters best left for juries because they are based on facts and inferences that must be drawn from people, and that there's information to that extent. As far as the noise and the violence, I mean, Maria Cruz herself testified that there were threats being made within the apartment amongst themselves. Any individual that is making those threatening arguments can foreseeably be someone with a temperament. Now, if NYCHA doesn't intervene...
Well, who was doing it? Was it the father doing it? Was it the son doing it? I mean, who was doing it?
She's testified familiarity with the husband doing it. The father moved out before any of these issues arose, before any complaints were made. He moved out sometime in the summer of 2015. The complaints did not start occurring until the winter or the end of 2015 and continuing. Now, finally, if I may, I know I'm running short on time, I didn't get to the final point, is that the foreseeability also goes to the fact that NYCHA didn't do anything to investigate. They were worried, or they did nothing. They didn't have a background check of this individual had they investigated. They received these complaints and they did nothing. Their records are deficient in as much as there are complaints registered in their appearance log that aren't otherwise found in their files. They didn't do any of these events, and ultimately, Maria Cruz testified that when she heard some of these threats, they would sometimes spill out into the hallway. She felt unsafe to leave her apartment because of the fights in the hallway, the disputes in the hallway. Every single one of the persons, whether it be the plaintiff, his brother, or Maria Cruz, testified.
When were those complaints made? After Mr. Gerard moved in or before?
All of them were after. All of them were after, clearly after. Maria Cruz had familiarity with his voice, which is how she was able to distinguish that it was him that was arguing. And finally, I mean, the issue is that you have all these complaints. You have to. He's asking for a determination on credibility that with all these complaints arising and being brought to the attention of NYCHA, that they had no duty. No duty had arose for them to even conduct a scintilla of an investigation. And in absence of NYCHA intervening, you were leaving the people, the tenants, to have to intervene amongst themselves and try to resolve the issue among themselves. A person who's living in an apartment like this where they're fighting with loud music and have a temperament, who is constantly getting interrupted by his neighbors every day who are knocking, asking to please excuse, is just asking for an escalation of a matter. And these
the neighbors were not complaining about the fighting. For the most part, they were banging on the door so that they would stop playing the loud music.
They were collectively complaining about all these events happening. I don't think that from the record or the testimony you can separate the events from my recollection and review of the record.
Isn't that why the plaintiff here went and banged on the door, because they were playing loud music?
Yes.
He didn't bang on the door because they were fighting.
No, but the issue is that because he had tried to get intervention from NYCHA and nothing had been done by NYCHA, and he had called the cops and they weren't really able to do much, and he had called 311, he had exhausted all the remedies available to him to seek help and intervention from people with authority, and he had to himself go to the door. And when
Because of the loud music.
Right, but when you put people in a circumstance like that where they have to do that constantly and ask their neighbor, it is not unforeseeable that on one circumstance you could catch your neighbor in a bad day and knock on their door when they're in a temperamental mood and something could happen. I'm not saying...
So basically, he's knocking on the door because of the loud music. And he's calling 911 because of the loud music. And he's complaining to NYCHA because of the loud music. And you're saying that should put NYCHA somehow on notice that Mr. Gerard has vicious propensities, that he's a danger to the other residents of the other tenants in the building.
I respectfully disagree with your categorization of it as simply loud music. It was very clearly testified to that it was instances of loud music, but also loud and violent banging, cursing, screaming, arguing, things of that nature. Loud music alone, I mean, if you wanted to bump Taylor Swift in your apartment, I might knock and ask you to knock it, to turn it down, but I wouldn't be afraid of you assaulting me. But if you exchange those other circumstances...
Mr. Gerard never threatened any of those folks when at any time that they had any interactions. He never made any threats to any of them.
Well, as the lower court said in its ruling in denying and finding an issue of fact, it says that to grant this motion would be asking the court to severely restrict and redefine foreseeability. So the fact that Gerard maybe never said, I'm going to kill you before that, or had maybe gestured like this, doesn't mean that the people didn't feel threatened based on his totality of circumstances and his actions.
What were his actions? That's what I want to know. What were his actions towards the people that complained about his behavior?
A disrespect for their considerations, which required the neighbors to constantly have to ask him and confront him. And the constant confrontations will build tension. And when those tensions finally erupt after 16 months of this ongoing, it's not unforeseeable that if left alone without intervention of someone with authority, that these constant interventions...
So the fact that he disregarded their complaints to you, that would constitute somehow a threatening action?
And that they had to keep making the complaints. They kept having to approach the door of an individual that they had maybe just heard screaming obscenities and
Counsel, are you asking us to redefine the foreseeability element and define it in such a way where if nothing is done by the housing authority and that an individual has to continue interacting with a person, that somehow enables a tinderbox for an explosion? Is that what you're asking us to do?
Sort of. I would tweak what you said to say that if, especially in circumstances where they're required to continuously interacting with someone that has shown vulgar and aggression, even if it's not directed at them, but someone within that apartment they have to approach, because that person is then showing a temperament of aggression and violence and vulgar, and you now have to confront that, not because maybe you're not even, you could not be concerned for the other person's side if you truly lack empathy, but you don't want to have to listen to it and live in a circumstance where that's the environment. These are people that can't move out of this apartment freely. They're living in NYCHA because of social needs. It's not like they can call their real estate agent and move out because they don't like their neighbor within a month.
Thank you, counsel. You'll get another question?
No. That's enough. So, counsel, can you address that? Is it foreseeable that Mr. Gerard would engage in the acts that he did engage in simply because he disregarded their complaints?
Absolutely not, and that's not what the standard of foreseeability is in the law. And
Well, what is the standard? Your adversary says that similar acts, criminal acts, is really a second department standard. What is our standard?
oh, that's sorry, I don't want to interrupt again.
Go ahead. What's our standard?
It's Maria T., which is a first department decision, citing the second department decision in Novakova.
What does Maria T say?
Maria T. cites Novakova, and it says, while it doesn't have to be identical to criminal activity, and then it cites Novakova, and then it says it does have to be sufficiently similar criminal activity at a location at or near where it happened in order to be foreseen.
Counsel, Maria T, aren't the facts clearly from the facts that we have in this case?
I'm sorry?
Maria T, aren't the facts of that case clearly distinguishable from the facts of
I'm
this
talking
case?
about the standard that Maria T sets in terms of foreseeability, and what the plaintiff is asking is a different standard and placing a different duty on landlords such as NYCHA now that has nothing to do with the standard that has been followed by this court and other courts, including the Court of Appeals. I actually argued, I was on the Scurry decision, and it didn't overturn Novikova or the standard when it came to foreseeability. So that's the issue. What the plaintiff is asking is to establish foreseeability based upon non-criminal activity and based upon subjective impressions on that non-criminal activity, which should not be the standard, because then there's going to be unlimited liability, and foreseeability will have no meaning. I mean, just to sum it up.
Did NYCHA do anything about these complaints? Were there any investigatory steps taken?
There were noise complaints, and the sister, Ms. Gerard, was spoken to. But what the plaintiff seems to be saying is that NYCHA should, because the standard is NYCHA tenants are allowed to have family visit and stay with them. And so what the plaintiff is saying is that anybody that stays with a NYCHA tenant has to be investigated before they can stay.
But that's not what plaintiff's saying, right? Plaintiff's saying that there were complaints about that apartment, and insufficient activity was done by the housing authority to deal with the specific complaints and the feelings that the neighbors had regarding the situation.
And NYCHA did evict this person, correct?
It still doesn't establish foreseeability of a violent criminal assault. It doesn't establish foreseeability of an attempted murder. If you take all the evidence in this record, again,
From the evidence in the record, can we glean that NYCHA did anything in relation to the complaints that were made to NYCHA?
NYCHA did respond to the noise complaint and did have an interview with Ms. Gerard, and impressed upon her that she was supposed to keep things down. But that doesn't.
Complaints were received after that, right?
I'm sorry?
More complaints were received after that meeting.
I believe that was shortly before this incident, this situation. But again, it doesn't establish, even if NYCHA didn't, according to the plaintiff, appropriately respond to the noise complaints, it doesn't establish foreseeability of a violent criminal assault. That's the bottom line, and that's the standard that the plaintiff is attempting to change. The plaintiff is attempting to change the law when it comes to foreseeability.
Thank you, counsel.
Thank
Thank
you.
you both. Khatib versus Njar, and I am recused.
Yeah, I got it. Thank you. You may proceed, counsel. You can proceed.
Thank you. Good afternoon, Your Honors. May it please the Court. My name is Amal Umi. I am the attorney for appellant in this case, Mr. Farid Njar. Your Honor.
Ms. Umi, just to start out, are you disputing the terms of the Casablanca judgment that was affirmed by the Court of Cassation?
Your Honor, our position is that the Casablanca judgment, as confirmed by the Court of Cassation, the highest court, has to be given full effect. In that judgment, the Court of Cassation clearly states the opposite of what was held by the trial court in this case. That judgment specifically states, one, reciprocal obligations between the parties pursuant to the 2012 conciliation agreement.
But they ruled in favor of Dr. Kotby, though.
Your Honor, the court only ruled in favor of Mr. Kotby because it narrowly ruled on 2 points. One,
It awarded him a judgment in excess of $340,000, right? Of 40
Your
yeah.
Honor, if I may go back just to, if I
Please
may.
answer my question. They did give him a big money judgment, didn't they?
Your Honor, what the
You can
Court of
dispute big if you want.
Yeah, the answer is yes. They did affirm the acknowledgement of debt by Mr. Njar toward Kotby. However, it is because the law in Morocco, as they explained it, and it's in that judgment, Kotby, Mr. Njar has to act first. He must render the money according to the conciliation agreement. His obligation comes first. Only once he gives the money, which they interpreted strictly as an acknowledgement of debt, only then is the question of the waiver and what would suffice as a waiver can be considered, which, Your Honor, is still on appeal to the Court of Cassation. Maybe it is still on appeal, Your Honor, to the Court of Cassation. I would like to
So
clarify.
you're saying that the judgment is not final?
Absolutely not final, Your Honor. We are submitting that is on the face of the Court of Cassation judgments. A simple reading of plain and ambiguous language of the Court of Cassation explaining why it is not final is there. Giving preclusive effect to a judgment requires giving preclusive effect also to the findings
counsel-
of the highest court.
Sorry to interrupt you, but we're one of the two decisions here. We're enforcing CPLR 5302, which provides a judgment can be enforced in the states if it's final, conclusive, and enforceable, even though an appeal is pending. So how do you deal with that?
I deal with that, Your Honor, is there was parallel litigation going on in Morocco. While the
In
litigation,
Marrakesh and Casablanca. Right.
I understand. One case was taken to its conclusion, which is the Court of Cassation awarding Dr. Kotby the $242,000 plus penalty. We concede that. We're not arguing about that.
That's fine.
However, at the same time, there were two contradicting judgments from two magistrates in Morocco at the same level. When you have that under the law of Morocco, there's two options the Court of Cassation can undertake. One, they can choose one and reject the other and say, we like the Marrakesh decision, we don't like the Casablanca decision because it's from two different cities. But they had a second option, which is to say that Kotby's, the acknowledgement of debt is there. We acknowledge it, that he signed that agreement, he has to give him the money, but we're going to remand the other contradictory judgment that says that the conciliation agreement is annulled, terminated. Now, I concede, Your Honor.
But
we concede.
The question is, that money judgment that was issued and that was affirmed in the highest court, is that a valid money judgment? Is it a final money judgment?
Your Honor, our position throughout has been that it is not enforceable where it's rendered due to Article 433 and 437 of the Moroccan law. The experts did not agree on much during trial, but they agreed on one thing. No judgment, when you have two contradictory judgments in Morocco, as probably would be the case if the state of New Jersey and the state of New York issued two separate judgments, no judgment is final or enforceable until such time as the president of the tribunal where the judgment is sought to be enforced makes a ruling that makes
The judgment is being enforced in New York.
Your Honor, but in this case,
So
Your Honor,
basically,
Your Honor,
court in New York
Your
decided.
Honor, the enforceability, my understanding, I believe I'm correct on the law, is whether it's enforceable in the jurisdiction where it was rendered, not whether it's enforceable in New York. If it's not enforceable in Morocco, it cannot be found to be enforceable in New York.
So a
Because-
judgment issued by the highest court in Morocco would not be enforceable in Morocco?
Your Honor, the judgment issued by the answer is yes as to the recognition of judgment. No, it is not final as to the issue of what Dr. Kutbi has to do in order to get that $242,000.
Is that what we call a collection?
No, Your Honor, it's not what we call collection. It is a completely different process. It is detailed in my brief and also in my cross motion for summary judgment. But there has to be service, which is the equivalent of notice of entry here to date. Today,
Counsel,
Njar
you
has
do
never been
unpack that in your brief a great deal, and I've let you go over time quite a bit.
I'm sorry, Your
We'll
Honor, I
talk
didn't
about
hear.
interest.
I
Oh,
didn't hear.
you do unpack what you're saying now in your brief at length. Thank you. I've let you go over time quite a bit, and I know you want to talk about the interest and how it was calculated here. So let's talk about that on your rebuttal time. Be prepared to talk about interest. Thank you.
Thank you, Your Honor.
May it please the court, Robert E. Malchman, Allegard, Berger, and Vogel LLP for plaintiff respondent Nabil Khatbi. Of course the Casablanca judgment is enforceable, and it is final. There is no other litigation arising out of the Casablanca judgment, nor can there be. As the court noted, this proceeded on two tracks. Mr. Njar prevailed at the Marrakesh Court of Appeals level on the grounds that he had been paid, which was patently false. The judge was, I don't know, wrong.
Speaking of the, can I just put a pin in the two tracks for a minute? Do you need, depending upon how we rule in this case, do you need a second judgment? I mean, a single judgment should be sufficient arising from these two proceedings, correct?
I agree. I just wanted to explain where we are in Marrakesh.
Oh, okay, please.
Dr. Khatbi appealed that decision. The Court of Cassation overturned the judgment of the Marrakesh Court of Appeals. That is, Dr. Khatbi prevailed. It was sent back down to the Marrakesh Court of Appeals. The Marrakesh Court of Appeals has now adopted Dr. Khatbi's position, rejected Mr. Njar, and Mr. Njar is taking another appeal up to the Court of Cassation, and it hasn't done anything yet. But the money judgment, which is out of the Casablanca court, that's there, hasn't gone anywhere.
Is that a
Nothing's gonna
final
happen to it.
judgment?
I'm sorry?
Is that a final judgment?
Yes, yes, it is a final judgment. There's nothing else to do with that case.
Other than collect on it,
Sorry?
enforce it.
Yes, and that's what we're trying to do here in New York. There's no rule that I know of that says you have to enforce in the jurisdiction where the foreign judgment was obtained before you can come to New York and enforce against assets here. Both the parties are Moroccan-American citizens.
Right, and you have money in escrow still, correct? It's being held?
No, it's been paid.
Oh, that's been paid out.
It
I
has
see.
been
So
paid
you're
out.
just arguing about the balance now?
We're arguing about the balance, although
Well, there's also the question of interest, which I want you to address.
Yes.
Because there's a question about what the term garama means in Moroccan Arabic, and whether it is a penalty or it's
Right.
just a form of interest. And you argue it's a form of interest.
what it can't be is that a contractual late payment charge, let's just call it a charge, which is neutral, is enforceable or not under New York law based on whether it's a late fee penalty or a late fee or late fee interest or default rate of interest. It can't turn on that kind of semantic distinction. The word penalty in CPLR Article 53 deals with New York law. So we look to New York law as to what a penalty is. And I respectfully refer the court, this was provoked by, advised by the reply brief, JP Morgan Securities versus Vigilant Insurance Company, 37 NY 3rd 551 of 2021. The Court of Appeals said, the term penalty is commonly understood to reference a monetary sanction designed to address a public wrong that is sought for purposes of deterrence and punishment rather than to compensate injured parties for their loss. Here, Dr. Copy has had to wait 11 years to be compensated for his loss. And the 1% agreed by the parties, the garama, it doesn't go to the state of Morocco, it doesn't go to the state of New York. It's not a fine, it's not a penalty in function, even if that's a literal translation of the word garama. And we have our Moroccan law expert, who's both a member of the Casablanca Bar and the New York Bar, explaining that it functions in the contractual sense as interest. So this court, all New York courts, regularly enforce 1% late fee payments. They enforce actually higher numbers than that.
It's 1% monthly, correct?
1% per month, so 12% per year.
It's compounded, I presume, or not?
No, simple.
It's not compounded, okay.
So it's a...
It's not usurious under New York law, you can say that.
Right, it's not usurious, and it's something that is regularly enforced by New York courts. Now, we have not cross-appealed, and I don't want to mislead the court in any way. We figured we would take the 3% per year haircut rather than spend the money to try to jack up the judgment. If the court has any other questions?
Any other questions? Thank you very much, counsel.
Thank you, Your Honor.
Your Honor, respondent is, first of all, arguing whether the penalty, which is called penalty fine, in each and every single judgment issued by Morocco, he's suggesting Moroccan judges do not know the difference between the word gharama and the other word, which means interest. The only person who did not know the definition of this word is the translator that was used by Mr. Melchman throughout the trial, the 9-day trial that we had in this case. He cannot argue now, without having filed a cross-appeal, for some sort of affirmative relief.
No, I know that it comes up because you're disputing whether Judge DeAugust should have imposed the 9% interest and prejudgment interest, et cetera.
Well, Your Honor, what we're disputing is that
He did that only because he didn't think that the 1% garama was legitimate.
Your Honor, the Supreme Court already made a decision that this was a penalty, not a fine. So operating from there, this is not pass-through payment. He can call it many things, but it's not those things because the judges in Morocco know the difference and the judgments say that it's a fine penalty. Now, in terms of whether it can be collected, it will be collected. This is exactly how Dr. Kuchbi is going to get the windfall. Because in Morocco, it is still enforceable. If Mr. Njar loses his appeal to the Court of Cassation, then Dr. Kuchbi will be collecting the $242, the original debt, an additional $26,000 of penalty that was already paid with the escrow, the bank interest, which he negotiated and got in the so-ordered stipulation of August 1st, 2013, making him whole, and I believe that the case of the Dario is right on point there. So he's not entitled to prejudgment interest. The prejudgment interest is not available under the CPLR 50 to 54 when you're recognizing a foreign judgment. The ministerial duty is to recognize the judgment and give it effect, and not to pick and choose what you're going to give preclusive effect.
Well, here, of course, there was the bench trial, too, and the breach of contract claim that was tried at the bench trial. So you had these two tracks going on.
Your Honor, but on the bench trial, if I may please, it should have been...
Finish up, though, counsel. Thank you.
That parallel case is now under review by the Court of Cassation in Morocco. The breach of contract has not been decided yet. The law of the case, as established by the Honorable Singh, was that the cases need to be stayed, nothing should be done until there is final resolution of all the litigation in Morocco. That hasn't happened.
You mean Judge Singh, who was sitting to my left a minute ago? That was in 2013 he did that.
That was the law of the case throughout. We filed several motions. That was the law of the case, Your Honor, because when the judge lifted the stay in 2018 for the trial, we had a judgment in our favor annulling and terminating the conciliation agreement.
You talk about that in your brief. Thank you. Thank you both.
Thank you.
Next case is People versus Perkins.
Good afternoon, Your Honors. Harold Ferguson for Appellant Robin Perkins. Just last month, I was before Justice Singh and Justice Mendez on what I considered stare decisis day, and that's basically the issue here. What we were asking this court to do is to re-examine Guerrero in light of the Third Department's decision in COS. And I have to say that...
How far are you asking us to go?
And again, this court has the ability to answer one of the questions that the Third Department raised in COS. The Third Department indicated that they thought that only the statutory issue was raised in Guerrero and that the constitutional issue upon which they made the determination in COS was not raised in this particular court and played no role in the decision. We have no way of knowing that because the decision in Guerrero does not mention any constitutional issue. And all we were asking this court to do is, this is the first court to take a look at this issue post-COS, which happened in 2019, and we're asking this court to re-examine Guerrero. If it determines Guerrero was correctly decided, we lose. If Your Honors determine that COS was correctly decided, we win. Either way, it will obviously go up to the Court of Appeals because it's a split jurisdiction.
Is there something inherently unfair in allowing the prosecution to charge in a Superior Court information a level of degree which is higher than that which appears in the felony complaint?
That is essentially what COS is saying, that what they're saying is that the constitutional amendment, which created the waiver of indictment, mentions nothing about joinable offenses. And what this court and what the Fourth Department did in their decisions was that it read the statute afterwards to include joinable offenses. And obviously, robbery would be a joinable offense to the petit larceny and the grand larcenies that were contained in the original felony complaint. However, the issue as to whether or not the constitutional provision prevails over it was not raised. The argument that the Third Department said that it wasn't raised in this court, and we believe that if this court follows COS, we would prevail. And that's the simple way. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors, and may it please the court. Bridget White for the people. Defendant was properly charged with third-degree robbery because it was joinable. This is the same factual scenario as Guerrero, where this court upheld a conviction under the same circumstances.
Now, 195.20 is an implementing statute. It implements the provisions of the Constitution.
That's right, Your Honor.
The Constitution says one thing. If you're going to charge me with a felony, you got to indict me.
That's right.
Okay, so didn't it go a little bit too far in saying, you know, I can charge you with a higher degree crime even though I don't go to the grand jury? Because that's not what the Constitution says. The Constitution says if you're going to charge me with something, you have to indict me. But a Superior Court information is not an indictment. So how do we somehow make sense of all that?
Well, you're right, Your Honor. The constitutional provision is silent as to the joinability. The Constitution does not prohibit this. The statute 195.20 was enacted in 1974, the same year that the amendment went into effect, and the statute actually provides more protection than the Constitution.
Provides more and yet allows a prosecutor to charge a higher crime than that contained in the felony complaint without going to a grand jury?
Yes, Your Honor. The constitutional provision doesn't limit what can be charged in the SCI, but the implementing act of 195.20 limits it to those offenses that are joinable. So it cabins the scope of what the prosecution is allowed to charge in the SCI.
So basically what the Constitution requires is that before I get accused of committing a felony, that the prosecutor go into the grand jury and present it to a group of people, right? Who will then take a look at the evidence and determine whether or not there's reasonable cause to believe that I've committed the offense. But here, we're taking it out of that forum and giving full discretion to the prosecutor to decide whether or not I'm going to be charged with a higher offense.
Well, Your Honor, I disagree that it gives full discretion to the prosecutor because this is a remedy the defendant must consent to. Defendant has to agree to be prosecuted to the specific charges in the Superior Court information. And here there was no unfairness to defendant on robbery third. Defendant could have faced from 2 to 7 years in prison. Instead, he was offered a repleader agreement where he had the opportunity to have the robbery charge dismissed and have time served on the petit larceny. This was a very favorable deal to defendant.
And counsel, was it favorable because there was some sort of treatment plan put in place?
Yes, that's right, Your Honor. But the repleader agreement allowed defendant an opportunity to seek mental health treatment. And defendant doesn't allege that this was not a voluntary and knowing waiver of right to indictment.
What would be the harm in following Cox and saying that you can charge something that appears in the felony complaint or a lesser included offense as opposed to a offense of a higher degree? What would be the harm in that?
Yes, well, Your Honor, the people respectfully submit that Cox was wrongly decided. The Third Department, there's no textual support in Article 1, Section 6 of the Constitution for the proposition that a higher grade offense may not be charged. The only language that the Cox Court was able to point to was emphasizing the words, upon a charge for such an offense, and you'll see that in defendant's reply brief at the bottom of page 5.
What about the Constitution that says that if you want to charge me with a felony, you have to go to a grand jury and get an indictment?
With the exception of if defendant agrees to waive indictment and it's one of the categories of offense which defendant can waive indictment for. So he can't waive indictment for a crime punishable by life or death imprisonment. But if he agrees, he can waive indictment.
That's what 195.20 says.
That is in the Constitution as well, that he cannot waive indictment for a crime which he could be punished with life or death, life imprisonment or death. But I believe the Cox Court misconstrued that particular section of, or part of Section 6. When you read the entire sentence that comes from, it reads, no person shall be held to answer for a capital or otherwise infamous crime, with some exceptions not relevant here, unless on an indictment of a grand jury, except that person held for the action of a grand jury upon a charge for such an offense, other than one punishable by death or life imprisonment, provided the district attorney consents, may waive indictment by a grand jury. With the whole context, it's clear that for such an offense refers back to capital or otherwise infamous crime. So it's not saying that the defendant can only be held or can only be prosecuted by SCI for crimes that were present in the felony complaint. It's saying, it's referring back to the type of crime which would normally need to be indicted. So I think that becomes clear when you read the entire sentence. So I think the Cox Court misapplied that, and this court should follow its reasoning in Guerrero. If there are no further questions, we would ask that you affirm.
Thank you, counsel.
I really have nothing else to add. Thank you, Your Honors, for your time.
Want us
See
to
you
reverse
probably
ourselves.
next month.
Yes.
Arleysville Insurance versus United Fire. Anytime you're up, 1 minute.
Absolutely.
You may proceed, counsel.
Good afternoon, Your Honors, and may it please the court. My name is Tom Kaufman, and on behalf of Kennedy CMK LLP, I represent the appellant Everest Indemnity Insurance Company. Your Honor, this is an appeal concerning one single issue of the various issues that were decided in the decision below, and that is whether it was premature to require my client to indemnify as opposed to just defend commercial construction management, or CCM, in the underlying personal
And why is
injury
it
action.
premature, counsel?
I'm sorry, Your Honor?
Why is it premature?
Sure, Your Honor. So the insurance policy at issue, my client's policy, limits the scope of coverage to bodily injury that is caused in whole or in part by the named insured, which in this case is United Fire Protection. In 2017, the New York State Court of Appeals in Burlington versus New York City Transit Authority said, essentially gave a heightened standard to what caused in whole or in part means. They said what it means is not just but for causation or causation that you'd see in additional insured endorsements that use the term arising out of. It said that there has to actually be proximate cause by the named insured. Since that decision came down, numerous appellate and trial court authorities have said that when these disputes get before the court, sure, you can make a determination on the duty to defend and decide the insurer has a duty to defend. And in fact, that happened below, and we're not contesting that portion of the decision.
And that determination essentially is based on looking at the pleadings to decide whether or not it's contained.
Exactly. And
how is indemnification different from the duty to defend?
Sure. Well, indemnification is ultimately you now have to pay the judgment, the resulting judgment, settlement, so on and so forth. And it's a different standard. It's essentially what actually happened versus the duty to defend, which is what's reasonably possible to happen.
So without a determination as to causation, you say premature.
Exactly. And we've cited several authorities in our brief that essentially say just that. That say, sure, you can rule on the duty to defend, but until the underlying action has actually adjudicated proximate causation, the duty to indemnify is premature. And at that point, you can stay the DJ action, you could dismiss it without prejudice, you can, whatever the court wants to do from a calendar management perspective. Now, all those cases that we cited are not discussed, rebutted, distinguished, or anything in the respondent's brief, and the sole case advanced in opposition is WDF versus Harleysville. That case actually illustrates our point. In that case, what the appellate division said, I believe in 2021, was that not it can decide issues of causation under these circumstances, but in that case, that it was actually required to because the underlying negligence action resolved without a finding of negligence. And if you look at the trial court opinion for which we provided the citation in our brief, in fact, one of the first sentences of the case is the underlying personal injury action has already settled. And not only that, but the additional insureds, WDF was the purported additional insured in that case, in the underlying action, their claims for indemnification and whatnot against the carriers named insured had been dismissed at that point. It actually underscores our position, Your Honors, because in that case, by the time the DJ action was set to be adjudicated, there was no parallel negligence action where you run the risk.
There was no even determination of liability because the case settled.
Exactly. And so in that circumstance, what the appellate division, I believe, was saying was, it's not that we can make that determination here. We have to, because the underlying court did not make it before it resolved. That's not the circumstance here. The underlying action remains ongoing. There's no evidence or indication in the record that any liability or causation has been assessed against United Fire Protection. And so we contend that this is just another case where the duty to defend, even if we disagree with the ruling, we're not contesting it at the appellate division, but the duty to indemnify was simply premature.
Counsel, am I correct that plaintiff didn't request a determination on duty to indemnify? Am I right?
That's correct too. In the notice of motion, there was no specific request for the duty to indemnify as well.
Thank you, counsel.
Thank you very much.
Good afternoon, Your Honors. Adenine Medina from Barker, Patterson, and Nichols on behalf of the plaintiff respondents.
So are you asking us to create another exception or to recognize another exception as we did in WDF? Or what?
I don't believe there's a different exception. I think WDF.
So it's the same. So how does that apply here? As your adversary points out, that case was already terminated. So there had to be a determination there on causation, right?
I think this case falls squarely within the facts in WDF, and some of the sort of position of Everest as to the underlying procedural history of the case is not fully accurate. In WDF, the underlying personal injury labor law case had been settled as to the plaintiff.
And had there been any determination with respect to percentages and that kind of stuff?
There had not. In this case, the underlying labor law personal injury case has been decided as to liability as to the plaintiff. The claims vis-a-vis the third parties had not been decided in WDF and has not been decided in this case. So it's essentially identical in that sense. In WDF, and Everest points out that there was a determination as to the contractual indemnity issue as to WDF, but as this court points out in WDF, the issue that was addressed in the underlying action was a contractual issue, not an additional insured issue. And the court specifically says the contractual indemnity obligation was separate and distinct from the insurance company's duty to defend and indemnify the additional insured. So that's exactly what's going on here. The duty to defend and indemnify here is separate and apart from what was found in the underlying action here as to the plaintiff, Molina.
You'd agree that there's been no finding that United was the proximate cause of Mr. Molina's injuries, right?
Not in the underlying action. In this case, the court essentially made that determination.
The court did make that determination.
In the order appeal, they essentially made a determination that there was sufficient evidence for a finding of
in the underlying case.
That has not been addressed. And in fact, United never appeared. United has been in bankruptcy in the underlying action.
But CCM's still in that case, right?
Commercial is still in that case.
Yeah, so I suppose that they could have caused Mr. Molina's injuries in part or in whole. We don't know yet.
We don't know, and that probably will never be decided, but that did not preclude this.
Well, why won't that be decided?
Well, the underlying case has been determined essentially on liability with respect to the plaintiff.
Right, but as my colleague pointed out, what hasn't been determined is whether plaintiff's injury was caused in whole or in part by the acts of the adversary, right? And I suppose theoretically, jury could find no liability, no causation. Then what?
But that's exactly what was the case in WDF, where this court said because there hasn't been a determination in that action, we are now required to make that determination. And this court reversed and made a determination that essentially based on the record, there was sufficient evidence to demonstrate that there was proximate cause by the named insured. And that's what was demonstrated.
What's the posture of the underlying action?
The underlying action was, there was liability determination or a summary judgment, partial summary judgment on liability as to the underlying claim vis-a-vis plaintiff. The third-party claims have not been decided. The parties have been trying to negotiate a settlement in that case.
So let's assume there's a settlement without a determination. Then aren't you really in the exception within WDF?
Again, we're squarely within WDF. And in this case, as the underlying, the motion court found, there was ample evidence that the sole proximate cause of the accident was United. The plaintiff in the underlying action testified that the cause of his accident was a sprinkler pipe.
But I guess the question is who makes that determination? You know, that's at least that's the issue that I'm having, based on the posture of this case.
I believe this court has made that determination in WDF. In this case, is squarely within WDF, and it's within it's within this court's province to make that determination, as did the trial court. And for this reason, we believe it should be affirmed.
Thank you.
Thank you, Your Honors.
Counsel, 2 minutes.
So if I can just echo the key words, the 3 words that came out of that, Your Honor, was just we don't know. We don't know what's going to happen when we get, down to the determination of, proximate causation. And
but respond to your adversary's point. I mean, there's more than sufficient basis in this record that it was the insured's activities that really caused the accident.
Sure. So if this was a case where the trigger for additional insured coverage was arising out of the insured's operations, meaning just some causal connection between the accident and the insured's, the work that they were doing, maybe that's a different story. Here, it's actual proximate cause, and other than the fact that that our insured employed the plaintiff, there's been really no evidence of what they did that proximately caused the loss at issue. And in fact, we cited cases in our brief stating that employment by the named insured is not sufficient to state that a loss is caused in whole or in part by the named insured. Beyond that, there's legitimate issues of fact concerning what did in fact cause the loss. Some of the things we pointed to in our brief, for instance, were the underlying plaintiff, when the injury occurred, was installing sprinkler pipe on a ceiling. And he testified that the ceiling was in poor condition. He testified that complaints were made to CCM about the poor condition of the ceiling. And beyond that, The owners, 114 Fifth Avenue and Lululemon, who the trial court below correctly determined we have no obligation to defend or indemnify as additional insureds, would be the people who you'd think have the obligation to maintain the ceiling. So this, again, all goes to what the court or what the jury credits or does not credit below. Maybe they do say, yeah, it was all United Fire. Maybe they do. Or maybe they say, no, it's the landowner who didn't properly maintain the ceiling. Or it's CCM, the general contractor, who ignored complaints about the condition of the ceiling. It could be 100% the owners. It could be 100% the general contractor. We just don't know yet, and that's why indemnity is premature in this case.
Thank you. Thank you both.
Thank you very much, Your Honors.
Coresight, 32 Avenue. Normally, I don't get involved in terms of who presents first, but I think in this case I am, and I think really I want to hear first from Telex.
Yes. We kind of talked amongst
Yeah.
ourselves. And I
You're the
think
target
it
here,
makes
so
sense.
it makes sense they piggyback off what you have to say. So.
Yes, yes.
So
yes.
go
Thank
ahead,
you.
counsel.
Thank you, Your Honor. May it please the court, counsel. Robert Friedman, Shepard, Mullen, Richter, Hampton for Telex. I'm going to address the Coresight issues first, and if I have enough time in my initial presentation, I'll go to the owner's issues as well. There were three fundamental errors, fundamental and basic errors that the trial court committed in granting summary judgment for Coresight here. First, it ignored clear language in a contract. Second, it basically drew factual inferences and found facts against the party that was, against whom summary judgment was being granted.
So let's get specific. Let's go specifically to section 2909A. You say, I assume, they ignore to pay owners standard charges, correct?
Yes.
Okay, so tell me why.
Well, if you look, especially if you look at the way the provision is written, there is a whole sentence, and it's a rather long sentence, and it has two words that are important in owner standard charges. It has shall, and then it has a condition precedent. It has on the condition that the tenant shall pay owner standard charges. Then what happens is now there was a heavily negotiated and highly disputed next sentence. And that next sentence is an exception to the owner standard charges. It's the only way it can be read without writing out owner standard charges, because what those owner standard charges is.
But accepting your argument, doesn't it then write out what it says later about such amounts shall, same language, shall not be increased by greater than 3% or the CPI?
Yes, but
doesn't it write it out? If we accept your argument,
no,
so
absolutely.
how do you harmonize both those?
So here's the situation, and we also have to go to the drafting history, which I encourage the panel to examine.
Well, but if there's an ambiguity, right?
Yes.
If there's an ambiguity. So first issue ambiguity, then.
Absolutely. So what happened here is the agreement was owner standard charges. Then what was negotiated is that there's going to be essentially a preference period for 1 year, the reservation deadline date. So panels ordered in that period, that 1 year period, get charged the $700 plus 3% CPI for the rest of the term of the lease. And that's, I think, the crucial distinction here. That's how the 3%, such amounts, the word such amounts is key here, because that applies to those panels during that preferential period of 1 year. That is the way the parties negotiated.
Then the parties' behavior seemed to confirm the other side's position, which is that it stayed that way. In other words, that there were years of $700 per month charges with the CPI added.
Yeah,
For panels rented after, for panels that were rented after the reservation deadline date.
Yeah, also.
Excuse me?
For panels that were rented after the
Yes,
reservation deadline.
yes. Well, if I can answer both. So the factual history with respect to the post-contract, the post-reservation deadline date in the courts of conduct is an absolute mess. It is not consistent. If you go into the record, you will see that the owner, and Ms. Thompson can confirm this, was completely inconsistent in what they did. In many cases, they didn't charge for panels. In many cases, they didn't charge the 3%. And Coresight didn't pay the 3%.
Did they ever charge a rate like the rate that Telex was charging Coresight?
No, they did not. But I will also point Your Honor to the history with respect to Telex coming into the building. When Telex took over at that point in 2013, again, it was a mess. The owner couldn't run this building. They were not able to run the meet-me rooms and the co-location business. Telex essentially rescued this business from the owner because they couldn't do it, they couldn't bill, they weren't even billing consistently for the panels that were ordered. Telex comes in and tries to, and it's not just Coresight, there were many tenants here they had to come in and manage. And what happens is during this period then, Digital Realty acquires Telex. So just as Telex was getting its feet wet and stabilizing the building, Digital Realty comes in, and then once they again
So you're saying, in essence, and I'm sorry to cut you off, is that there's that course of conduct is not sufficient under these circumstances, given all what was occurring there, bad business management, et cetera. But when I look at 2909A, there's language that says during the term of this lease, such amounts shall not be increased.
Yes.
How what's the term of the lease?
The term of the lease is 15 years.
Okay, so when does that term end?
That term ended actually already.
2022?
Yes. But the key, it's for the panels.
So then don't you read out, we accept your interpretation, don't we read out during the term of this lease?
No, because it's for those panels. So the panels continue. The preferential pricing continues during the term of the lease. In this case, there were 3 panels ordered. Telex does not dispute that those 3 panels have preferential pricing during the term of the lease.
So you're saying it's the additional.
So it's crystal clear, as we say. I used that word, frankly, in 2019 when we were before the trial court, and the trial court disagreed and found that there was ambiguity here. My co-counsel for Coresight disagreed and said it is not crystal clear. In the decision below, the trial court then reversed itself on this language. The language didn't change and said it's crystal clear. To us, frankly, Your Honor, this is crystal clear. But certainly, if there is any ambiguity, we have to go to the facts. And this case is strewn with factual issues from the drafting history in which their witness, Mr. Rockwood, admits that he has no idea what the reservation deadline date is. He doesn't know what the owner's standard charges is.
But he did say that the reason why they entered into this lease was because they were going to get some type of preferential rate for these panels, because that's the only reason why they were going to be paying millions of dollars for this space.
We do not dispute that they had preferential pricing. I think that's the discussion I just had with Justice Singh, which is there are panels during that reservation deadline date that we do not dispute. They were always charged.
But they said they wanted it for the entirety of the lease.
That may be what he wanted, but this is what he says about the reservation deadline date. And this is his testimony, and this is at record 3398. What was your understanding at the time of the purpose of the reservation deadline date? So my understanding at the time was, I don't understand this. And it doesn't give us the protections we want. So Ari, that's their lawyer, go back and get the protections we need.
And the
they-
protections-
And if you look, I'm sorry, Your Honor.
And the protections was putting in the dollar amount that they would be paying with the 3% interest and the CPI.
Absolutely not.
was not
He
it?
was talking about the reservation deadline. He said the draft that came back, and I can give you the record site, Your Honor, is, if the draft that came back struck the reservation deadline date. And so his problem was the reservation deadline date, and that is on June 7th on 2007, 2171. And what they wanted, they wanted to go back to the letter of intent, which is record 1590, which just said $700. It's crucial to look at this drafting history because, again, it shows exactly what the parties were doing. What Mr. Rockwood then comes back in his testimony is basically his hope. And this is what the trial court relied upon exclusively, ignoring the documents. And we've all tried cases. I'd rather have the document in front of the jury and show them the document, which contradicts his testimony, than I would have someone's hope and 15 years later. And that's what now Telex has been deprived of. It's right to do in a case where Coresight says this is worth $100 million.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. May it please the court, Letitia Thompson at Morris & Cohen for the owner.
Do the owners concede that the contract is unambiguous?
No, the owner doesn't concede. The owner, throughout this litigation, has taken no position with regard to exactly what the contract means and how is this being.
You're just interested in indemnification.
Pretty much, and the point for the and it's an important point for the owner.
So let's go to indemnification.
Okay, sure. Part of what Mr. Rockwood said that is 100% correct is that the owner was not very good at managing this hub, and so it set up an arrangement that all parties agreed to, and the arrangement basically provides that if Telex is going to take over the operation of the hub and take over these leases, that the owner was going to be indemnified for anything that Telex did in the management of the
So that's 1902A, correct?
That's 19.
Oh, so what little I provision of 1902A you say best fits this dispute?
Well, interestingly, they all fit. Well, 1, 3, and 5 all fit, right? And there's no reason for this court to have to parse out, right? The trial court said, okay, we'll do 1 and 3. We argued it should be 1, 3, and 5. And ultimately, we believe they're all applicable. 1902A1 is very clear that Telex has the obligation to completely take on owners' obligations and respect the lease terms therein, right? Indemnify and hold owner harmless from all loss, costs, liabilities, damages, and expenses resulting from Telex's default under any provision of the lease. 1.07C in turn says Telex has to honor certain provisions of lease agreements with tenants that include pricing restrictions. As Telex's counsel has just said, there's no dispute that this lease includes a pricing restriction, right? Whatever the pricing restriction may be, it includes a
Which
pricing
you don't want to
restriction.
take a position on, but you're...
But there's a pricing restriction, and everyone agrees that. That's the one thing that no one's in disagreement on. Telex agrees on it, Coresight agrees on it. If there is a breach of 1.07C, as the trial court found, then we're entitled to indemnification full out flat.
And if Telex is correct, then you wouldn't be, correct, at this point? Or at least it would be premature to make that determination pending a hearing or trial.
On 1.07A1, 1. I think on A3 and A5 would still be applicable.
Well, 3 is a stretch. Use and occupancy, use or occupancy or manner or use of occupancy of the demised premises.
Certainly, the Meet Me room is a part, which is the hub, is a part of the demised premises.
But are there problems with the room? Is it leaking? Is it doing something that
There's
when we generally look at these kinds of provisions, which relate to use and occupancy?
There's nothing in the terms of this agreement that says use and occupancy is to leaks, right? There's actual equipment that's in the room that are in cages, that are in boxes. This is not something that's in the Ethernet. And they're in their use and occupancy, and Telex is responsible for all use and occupancy of that provision, including how much it charges Coresight and other tenants in that space. So it's covered by 1902A3, as well as 19.02A5, which is a more specific provision. And it's not the case, as Telex says, that the court cannot look at 1902A5. It's the same as if you have a provision for your house and one for your bedroom. It's inclusive. And we specifically asked for and sought indemnification pursuant to all 3 provisions. It is in our answer and our cross claims. We asked for it, and we moved for our complete, for summary judgment on the total of the cross claims. None of the arguments made by Telex with respect to why indemnification shouldn't be granted or why this matter needs to go to arbitration are correct. I mean, they're just basically wrong. And
do they have a right to demand arbitration?
Absolutely not. I mean, this is one of the things that I think all you have to do is look at the clear language of the section that they're relying on for something to go to arbitration. That section of the Telex lease, which is 2.05, really clearly says owner shall have the right to submit the question.
It pertains to market rates. Does this dispute have anything to do with market rates? And
No, this dispute has nothing to do with market rates.
Also, what you just read was owner has the option to do it.
Well, that's another reason, right? It's totally owner's discretion. The case law that we cited is that when a provision provides one party with the right, it's enforced how it's written. Telex in its reply or opposition, briefing's a little funky, reply or opposition has no answer to that, right? Their answer is, well, the court doesn't have to, when it says owner shall, that it really doesn't mean owner shall, it means anybody can. And that's just not correct. It's not permissible. The provision is also not mandatory. I mean, there's any number of reasons why. On the clear language, if you just look at it, 2.05 does not give Telex any ability to initiate arbitration. In fact, as reflected in the record, Telex asked owner because it knew it couldn't commence arbitration, and the owner declined to do so.
Did you argue below that they were not entitled to demand any arbitration?
Yes, I mean, of course we argued it below because this is the subject of the motion now. I mean, Telex makes this argument that we somehow didn't argue it while appealing that argument and determination. I'm not exactly sure, but we absolutely argued it. If you look at our briefing on the record, it reflects that we argued that they could not. And to the extent that Telex rests on its initial motion to arbitrate back in 2019, and says that owner won on that motion, they're just wrong. That's not what the record reflects. Owner lost that motion, right? Telex moved to compel arbitration. Coresight objected to compel arbitration, and owner said, hey, judge, why don't you stay this, whatever's happening in this action until you make a determination on arbitration? And the court said, no, I'm denying the motion to compel arbitration, and this proceeding is going forward, which was 100% consistent with what owner's position was. And if you look at owner's briefing, and I think it's...
Counsel, I think we've got it.
Sorry.
No reason to apologize.
Good afternoon, Abby Rudson from O'Melveny and Myers for the plaintiff, Coresight. So I'd like to start with the key sentence of the contract. Owner agrees that for the period...
Well, let's just be specific. Where are you? And,
Let's start with the second of
there's
two
just
sentences.
not a one-page contract here. So.
Yeah, that's a good point. Just so we are oriented here, the lease is almost 100 pages. We're talking about two sentences, the two sentences that talk about hub pricing. So owner agrees that from for the period from the date hereof through and including the reservation deadline date, which was in 2009, the rate shall be $700 a month, and such amounts shall not be increased by greater than 3%. There is nothing about that says the panels have to be ordered or installed before the reservation deadline date, and that is why the Supreme Court said you can't just add words that aren't there. It doesn't say that. It says the rate. The rate is $700 for the first...
It doesn't say the panels.
Correct. The rate is for basically the first year and a half, 2 years of the lease is $700 a month, and then it can't be raised by more than 3% a month. Now, Telex says, okay, but then you have this preceding sentence about owner's standard charges.
Also, yeah, to pay owners standard charges.
Right. So two things. One is, to be clear, the preceding sentence is about access to the hub. Owner shall not unreasonably withhold or delay its consent to get into the hub on the condition that Coresight agrees to pay owner standard charges for any patch panels or other equipment or space utilized therein. So that's the standard template lease sentence. You want to come into the hub, we agree to let you in the hub if you agree to pay our owner standard charges. The next sentence was negotiated. And what Telex has never come to grips with is that the way to harmonize the two sentences is not to add words that are not there to the second sentence.
So the owner standard charges, you say, are the $700 per panel?
Correct. As a matter of fact, that was the standard charge at the time, but that's not...
No, that's how you're interpreting the language.
Correct. And the canon of construction that Telex never mentions, even though we've obviously argued it repeatedly, the Supreme Court cited it, is that specific trumps general. When there is a general sentence, and particularly here, a general sentence, that's the template form contract sentence, and then a specific sentence, and again, particularly here, that was specifically back and forth negotiated, the specific sentence trumps. And so even if there is a conflict, I'm not sure that there is, because you could just say the owner gives you access if you pay standard charges, and then, oh, we agree that our standard charges will be $700, no more than 3% caps increase a year. But even to the extent there is a conflict, there's a canon of construction for dealing with that. It does not mean you call it ambiguous and go to...
How do we
extrinsic
harmonize
evidence.
both?
You harmonize them by saying that the owner standard charges is what we agreed to pay to get access to everything in the hub. And what the owner agreed for us was that for panels and for cabinets, which aren't an issue, that means $700 for the first 2 years, and thereafter cannot be raised by more than 3% per year.
And then during the term of this lease?
Correct.
And the lease, by the way, is it over? I thought it was 33, or is it 23 or 30?
So it was 15 years with 2 5-year renewal periods. So we're in the first renewal period now.
So it's not over yet?
No, we're still in the building.
It's 2033, right? Something like that?
Yeah, I think it was 2022, and then 2 5-year periods takes us to
2032.
Yeah. So the other canon of construction, it's not the only one I've got here, is that you read contracts in a commercially reasonable way and not to put one party at the mercy of another. Here, and again, this is not even extrinsic evidence, this is just the contract as a whole. Coresight was agreeing to rent an entire floor of the building for millions of dollars a year to build a data center and run a data center that requires connections through the hub. And as Mr. Rockwood testified, that is extrinsic evidence, so I won't say that, but the point is that this is an essential element of a data center business. They would not have signed a commitment to pay annual rent of millions of dollars for 15 years without pricing protection on a key input to their business. And as Mr. Friedman said, we did get pricing protection. Telex agrees with that. Their position is we got pricing protection for the first 2 panels. We now have over 100 panels in place. The notion that 2 panels of pricing protection was enough for a sophisticated party to sign a 15-year lease and spend the capital outlay to build it.
What if the deal was so much better, and I thought you made this point in your papers, that this was the best deal that Coresight could get? Someone talked about the other alternatives at the time that they moved into this space, and that the other alternatives were much worse, I mean, much more costly. So does that give rise to an inference, perhaps, that it would be just the 2 panels initially and then new panels at a different rate?
No, it's the opposite inference, and thank you for reminding me to get to that point. As Mr. Friedman said, the reason that Telex came in was because the owner of the building is a commercial landlord. They are not a technology data center type.
Everybody agrees.
Yeah, they weren't running this as a profit center. As Mr. Friedman said, they made a mess. They weren't doing the billing right. They weren't raising panel rates when they could, which, by the way, does not make the course of conduct a mess, because as Your Honor pointed out, the question isn't whether they did raise prices, it's whether they raised prices beyond what they were allowed to. They didn't have any obligation to raise prices by 3%. They were just never allowed to raise them by more than 3%, and they never did. But the point is, that actually makes the commercial reasonability of the argument that much clearer, because you have a commercial landlord that's about to sign a lease for millions of dollars in rent for a whole floor of the building. And Coresight says, okay, but you're telling us we have to make our connections through the hub, which is not, by the way, not technologically required, it's required by the lease. We agree to do that if you give us pricing protection. And of course, the owner was all too willing to give such pricing protection because they didn't care about it. They weren't running the hub as the profit center. They wanted to rent out this space. So that actually shows why the incentive would be to make the preferential pricing for the whole period. See, I'm running out of time, but I wanted to make one other quick point about this concept of Mr. Friedman saying that, well, in his deposition, Mr. Rockwood said he was not satisfied with $700 through the reservation deadline date because he didn't know what that meant. That's 100% true. But that's why 2 drafts later, Coresight said, well, then let's add, and that such amounts may not be increased by more than 3% a year, and the owner agreed. So that is the protection that Mr. Rockwood instructed his lawyers to get. One other quick thing, just on the extrinsic evidence, Mr. Friedman said there's some kind of conflict. I just want to be clear about this. There is no evidence supporting Telex's interpretation of the contract, which, by the way, the owner does not agree with. They just want to say they take no position. But in an off-the-cuff moment, before the lawyers got involved, the leasing agent for the owner said to Telex, this is the Telex representative that admitted this in his deposition, oh yeah, Mr. Steinman told me I was wrong. And that's not what the parties intended.
Does Maisley have competent evidence of that before her? Of this prior conversation, the one you just described? Was that before Judge Maisley, that came into evidence?
Yes, the Telex representative testified under oath at his deposition that the leasing agent for the owner told him, your interpretation is wrong. That's an admission by, I mean, obviously the testimony of the Telex representative, sworn testimony, was admissible, and the owner's admission, the owner's statement was, the court found it correctly, found it an admission against interest. Do you mind if I take one more minute to?
Sure.
Okay, because I was pretty light on my 6 minutes. So the one piece of evidence that Telex has, I think it's important to talk about because it just doesn't say what they say it says, is, oh, well, you have your guy saying that, but we have this email from the guy who runs the hub. Here's what the email says. In total, Jeff, it is my understanding the panel fee reservation has expired. Thanks.
That's Shelley?
Yeah, I'm sorry?
Patrick Shelley?
Yes. I asked him at his deposition, what did you mean by that? What's the panel fee reservation? I don't know. The panel fee reservation is not a term in the lease. You know what is in the lease? The reservation deadline date, and everybody agrees it expired in 2009.
Was he in the room when the lease was negotiated?
I'm sorry?
Was he in the room when the lease was negotiated?
No, he had absolutely nothing to do with negotiating the lease. He admitted this at his deposition. He also admitted, I'm just looking for the record, that he had nothing to do with pricing in the hub. This is a little unclear in Telex's brief, so I think it's important to read this to you. Did you have any responsibility for the actual business of the hub? What do you mean business? I mean responsibility for the billing, for attracting customers. If there was something installed that was something billable, a cabinet maybe, that would be something I would inform billing, the finance department about. Were you responsible for setting pricing at the hub? No. Were you involved in discussions about pricing at the hub? I may have been, but I can't. You don't consider that part of your responsibilities to comment on pricing in the hub. I would just give my technical perspective of the request. He had nothing to do with hub pricing. The record's clear, he had nothing to do with negotiating the lease. So his opinion, even if the email meant anything, which it doesn't, would not be admissible for lack of foundation.
Thank you, counsel. Counsel, I'll give you an extra minute.
Thank you. Thank you. I want to start with that email because it is very important. So the most important factual issue really involves the
But really, before you
drafting
get to the
history, but-
facts, you have to convince us that there's an ambiguity. So that's the secondary argument. Primary argument, there's an ambiguity, and respond to what your adversary said. It says nothing about the panel's lease. It's a general rate.
For the panels, it says the word panels in this owner standard charges. In fact, it's the only piece of equipment that's specified. It says 4 panels.
For panels?
Yes. The owner standard charges, which is what we're trying to charge.
But you're saying that, okay, maybe it covers the 2 or 3 panels that were part of this negotiation, but nothing else, right?
Well, no, but there is a protection. It has to be standard. It has to be standard charges. You can't go above that, so there is a protection built into that. However, what happens next, which is confirmed by the drafting history, is that there is a negotiated preferential period through and including the reservation deadline date. Such amounts will be 700. The key word is such amounts there. Such amounts, meaning the 700 through the reservation deadline date. Otherwise, there is no such thing as owner standard charges. You would write that right out of
Well,
this.
no, I think what your adversary suggested is the owner standard charge is essentially the $700
Well,
before the reservation date deadline, and then whatever the increases were afterwards.
But then the $700 doesn't mean, and the 3% doesn't mean anything. It says the owner standard charges and then through and including the reservation deadline date. And I will point out, I'm going to read some quotes if I may, Your Honor, but from both the court below and by my adversary. The court, based upon my reading of 2909, which I have to start with 2909 because it came first, and I can't get to 205 or the telex agreement until I figure out what this provision means. It does on its face appear ambiguous to me.
But that's not a ruling that it is ambiguous.
Excuse me?
She's not making a ruling there that it is ambiguous. She hasn't decided yet.
Well, I agree, but we had examined this at a hearing in 2019. The language hasn't changed.
But then she goes ahead and examines it and finds that it is not ambiguous.
Based upon, she finds based upon reading out owner standard chart, if you read the decision below, there is no explanation similar to what was provided here. The explanation that is provided by Coresight in their brief is that it's boilerplate language. It's not boilerplate. It has shall and it has a condition precedent right there. And it's crucial, really, to go to the drafting history here because everyone said that this was ambiguous language. And then we go to the drafting, and then we do discovery, and we find out we have documents which completely contradict what Coresight's position is, because their folks did not want the reservation deadline date. They wanted what was in the letter of intent, which is $700 for the term of the lease. And now, 18 years later, they've now gotten what was on April 7th of 2007, they originally proposed and was rejected by the owner.
But these rates have been increased with the 3% and the CPI increase. So the payment is not $700 anymore. Now is going
It would
up.
be the 3%, yes. But so there was an agreement that for the panels, For the reservation deadline date, it would be escalated by 3%. And that's what they tried. They tried to get that language out of the contract and to get the owner standard charges out of the contract, and they didn't succeed. We have, I mean, the record is actually clear on this.
Thank you, counsel.
Thank you.
Thank you
Sorry,
all.
I didn't get to address the indemnification.
We have the record. We're going to review the briefs. So, thank you.
Okay.
You're right. I apologize. You have an appeal. So you have 2 minutes on rebuttal. No, you don't have a cross. You have an appeal?
He does.
You have a cross appeal? Okay, you have 2 minutes. I apologize.
And I'll probably take it and
So did I get I got the extra minute from?
I was watching him. He gave you the extra minute.
I gave you the extra minute, I assure you. Go ahead.
Just to be brief, I've covered the indemnification point. Owner is entitled to indemnification. There's nothing in this agreement with Telex that supports sending the matter to arbitration. Owner's position is consistent in the court below and consistent here that the Coresight and Telex dispute need to be decided in the same forum, and no matter what forum that is, and before this court, as the court below, Section 2909A of the Coresight lease is only entitled to one interpretation. It cannot mean one thing for owner and another thing for Telex. It's the same provision, and both parties are required to abide by its terms.
Thank you.
Thank you.
Thank you all.
Thank you.
People versus Newsom.
Good afternoon, Your Honor. Stephen Strother from the Office of the Appellate Defender on behalf of Craig Newsom. Your Honors, Mr. Newsom claimed that his attorney, Marlon Curtin, told him that he had accumulated enough jail and good time credits that his plea was effectively one to time served. That was wrong. Actually, Mr. Newsom owed 8 months, regardless of the amount of credits he would receive.
Counsel, did you have a 440 hearing before the trial court?
We did have a 440 hearing, yes.
Did the trial court credit that interpretation?
The trial court did not credit Mr. Newsom, no.
And the trial court did have testimony from trial counsel, correct?
Yes. Yes, and he heard from trial counsel. So the problem here is that Mr. Curtin.
So shouldn't we, I think, defer to the credibility findings of the trial court?
No, and here's why. The specific reason, Mr. Curtin took the opportunity to defend himself. He filed an written affirmation in opposition to this motion. In that affirmation, he says, take a look at the notes I made at the time of this plea. My interpretation of the law in those notes is so correct that I could never have done this. Now, in papers written during the hearing, in papers written to this court, and in testimony, we established that Mr. Curtin had no understanding of the sentencing issues at play in this case. His interpretation of every statute is wrong. Indeed, he couldn't even identify the right statute at all. He's confronted with that information at the hearing. His testimony is at best evasive, and really it's dishonest. He pretty much does everything he can to refuse to answer questions about the core issue in the case. Did Mr. Curtin misinterpret the sentencing statutes? If you read the court's decision here, this hearing court decision, you wouldn't know any of this happened. It never comes up. All the court says about Mr. Curtin is that he doesn't have a criminal record, and he's been an attorney for 32 years, and he was calm on the stand.
Counsel, what took Mr. Newsom 17 years to bring this appeal?
So he explained that actually at the hearing. So Mr. Newsom, his attorney filed a notice of appeal but never sent it to him, and then he never knew he had to file a poor person motion. He got a job at Legal Aid as an investigator, and attorneys at that often told him, hey, here's how you actually get the appeal going, because he thought he had been told it took a long time, and because he had never been in the criminal justice system before except for an old YO issue at the time he took this plea, he didn't understand. He thought Mr. Curtin was his appellate attorney. He didn't know he got a new one. And then when he realized he could, he filed the poor person motion. Our office got assigned, and we've been representing him ever since.
Is there anything about the facts that support that Mr. Newsom would not have taken the disposition offered to him but for the representation by counsel?
Yeah, 3 pretty critical facts. The first is that Mr. Newsom turned down extremely favorable plea offers multiple times. Indeed, the records that Mr. Curtin made at the time of the plea showed he turned down 1 1/3 to 4 years immediately before 1 to 3. If all he wanted was a short sentence, he would have taken the plea. You also have the second issue, which is that the prosecution's case here is not strong. This was it was a hung jury. They didn't get a conviction.
Well, they didn't get a conviction on the top counts.
On rape 1 and rape 3, correct.
Right. They could have retried him.
Of course they could have retried him, but
And what was he facing?
What's that?
What was he facing on the first-degree rape?
25 years. Now, this court in People versus Lantigua, however, has said, it made very clear the only inquiry here is whether it was rational based on the evidence. It doesn't have to be a great decision or even a very good one to go back to trial. But I've yet to see a case where a person has found that they wouldn't have gone back to trial when the first trial had significant evidentiary problems like this when it ended in a mistrial. I mean, this is a case where...
Well, it ended in a hung jury, which was the basis for the mistrial, right? But he could have been retried with those same witnesses coming back and testifying before a new jury.
Of course he could have, but that doesn't mean he can't show prejudice. The weaknesses in the prosecution's case would still be the weaknesses in their case. He had a good faith basis for thinking he could beat the case. He almost did already once.
But he decided not to because he was offered a favorable disposition upon sentencing for the matter for which he was convicted.
He took the plea because his attorney told him that he would be able to go upstate, get a number, and go home.
So when we look at the plea transcript, there's nothing in the record about that, and all we see in the record is Mr. Newsom taking responsibility for his conduct and willingly accepting the time that he was being offered.
Well, he wasn't asked, did your attorney tell you when exactly you're going to walk out the front doors of the prison, because that's not something that any judge asks at any plea. So there would never
There's
have been a
nothing in
record.
the record to suggest that that was an issue. What's in the record is that the time frame that he received 17 years ago was a time frame that he accepted a plea for.
Yes, Your Honor, the reason it's not in the record, which is why we filed the 440 motion, so we could make a record about it, because these were off-the-record discussions between counsel and his client. Mr. Newsom has no affirmative duty to place on the record every single thing his lawyer says to him before he takes a plea.
I wasn't suggesting that he did. What I was, I guess, inquiring about, is there anywhere in the record that we find some issue related
If you just
to
mean the record of the plea?
the record in general.
It does not come up in the plea. It comes up plenty in the record of this 440 hearing because Mr. Newsom provides testimony.
Did it come up at the SOAR hearing where the same attorney represented Mr. Newsom?
No, although I would mention to the court that at no point during a SORA hearing would there ever be an appropriate time to mention problems you had with your attorney previously before. And also, Mr. Newsom wasn't given a choice of who his attorney was at the SORA hearing either. We want to make the point here, this claim was well supported by Mr. Newsom's testimony, and Mr. Curtin's testimony had significant credibility issues on the core issues. This court never discussed it. The hearing court never discussed that. The hearing court's decision makes no mention of that. Unbalanced credibility determinations that are not based on the actual record cannot be upheld, and that's why this one has to be reversed.
Thank you, counsel.
Good afternoon. May it please the court. Jennifer Westfall for the people. The motion court properly denied defendant's CPL 44010 motion to vacate his conviction. Defendant's description of the court's credibility.
Actually, that's what I want to ask you about, is credibility. How do you respond to your adversary's argument that in this case, at least, we should scrutinize and look to see what the attorney said, that it's inconsistent with the few notes that he had?
So the motion court had the advantage of seeing and hearing the witnesses, and therefore was in the best perspective to gauge their sincerity and reliability and render accurate credibility determinations. Defendant here bore the burden of establishing the facts underlying his claim with credible evidence. One offhand page of notes with a surrounding narrative filled by an incredible defendant only gets him so far. All the motion court had to do was find that defendant was an incredible witness for defendant's claim to fail. And in fact, the court could have found both witnesses incredible, and defendant still would have failed to satisfy his burden. Defendant makes much of Curtin's predisposition to defending himself. He was blindsided by this. He had no idea, and he filed the motion because he had received what he deemed was a threatening letter from counsel, and he took action and hired a lawyer. Was that the smartest thing? I don't know. But he did what he did not to, it doesn't make his testimony any less credible that he filed a motion. The little discussion of Curtin's testimony was needed in the decision itself because he was largely an unproblematic witness. Unlike
How did the court describe the defendant's conduct and testimony at that hearing?
Evasive and inconsistent and non-responsive to an almost comical extent. As the one that bore the burden, that renders his claim unsupported by any evidence. The court's determination that defendant presented no credible evidence to support his ineffective assistance claim is amply supported by the record itself, and he advances no valid basis to overturn that motion court's decision. If there are no further questions, I respectfully request that you affirm.
Thank you, counsel.
So I'm going to make 3 quick points. The first is that that may have been the motion court's description of Mr. Newsom's testimony, but it is nowhere near an accurate description of his testimony.
But your adversary makes the point, and it's a point that we hear every day, is that we defer to trial court because trial court heard and saw the witnesses. We have a cold record, and so our reading is very different than when all of us were in trial court making those kinds of determinations.
Let me give you an example from the record of what I mean about the trial court's extremely unfair view of Mr. Newsom's testimony. A major part of the court's decision is that Mr. Newsom said that his military discharge was honorable under general conditions instead of general under honorable conditions. There is no discharge category called honorable under general conditions. There's just honorable and then general under honorable conditions. It's a transposition of the tongue. He slipped up. That counts for so much in the trial court's decision, just multiple paragraphs on this one slip of the tongue. Mr. Curtin comes in and straight up lies about what is in his own affirmation, trying to defend himself, and it doesn't come up in the court's decision. That's not a fair decision. I want to make a second point here, which is that Mr. Curtin filing a motion by itself probably doesn't affect his credibility too much. I do want to mention that there was no threatening letter from counsel. We sent him an ABA decision saying that ethically, defense attorneys shouldn't talk to the prosecutors when their clients accuse them of ineffective assistance. We sent him the opinion. That's it. The fact is, he had no standing to file the motion. He also refused to testify except via subpoena. And then when he came in, he made it very clear that he had no interest in talking about the affirmation that he filed. Why? Because undersigned counsel submitted papers showing him that he did not understand any of the sentencing issues. The court ignored all of this. The critical issue was, did he understand the sentencing issues? How did he advise his client about how much time he would have to serve? On those points, his testimony was evasive and dishonest. They cannot say the same about any of Mr. Newsom's testimony on the core facts of this claim. They were consistent every step of the way. We think for that reason, this decision was unfair, biased, and must be reversed.
Thank you very much, counsel. Thank you both. Knoll versus 336 East 95th Street. You may proceed, counsel.
Good afternoon, Your Honors, and may it please the court. Ross Frisha for appellant owner in this matter. The motion court erred in granting third-party defendant Champion's pre-discovery motion to dismiss on the ground that appellant owner failed to allege that he suffered a grave injury. In fact, the owner's complaint...
Grave injury.
I'm sorry?
What is the grave injury that
Grave injury here is the permanent loss of use of an arm. And
but no, the statutory language is permanent and total loss, right, of a body part?
Yes.
In case you're talking an arm?
Yes.
And
So-
that's the allegation here?
Yes, Your Honor. So if you look in plaintiff's bill of particulars, he alleged that he sustained, and I quote, severe permanent injuries of several parts of his body, including his left and right arms. You can see that on 87, which included loss of function and motion. And then on page 88 of the record, the bill of particulars specifically alleges that the loss of use of the above-mentioned parts was permanent and continuing in nature.
Any language about total?
I'm sorry?
Anything about total?
Total, well, the continuing would be the total, so permanent and continuing.
So total and continuing are, in your view, the same?
Well, the standard here is that at this stage of the litigation, if plaintiff has pled an injury that may fall within the definition of grave injury, under any definition, and I would argue that there still is discovery that needs to be had as to the extent and scope of plaintiff's injuries here, because continuing could be continuing for his whole life, and permanent is in total as well. I mean, permanent and continuing would be total.
Well, you would concede that it doesn't track the statutory language, right?
It does not say the word total, but I will say that as per the decision in O'Flaherty v. Colombo, a case in which Justice Moulton sat, that's 202 AD 3rd 509, the term grave injury doesn't even need to be specifically worded that way. In fact, in that case, the plaintiff alleged.
Well, for example, if his arm, if he had lost his arm, we wouldn't be arguing about that, right?
Well, I mean, we're looking at the bill of particulars, just the pleadings, so we can't say what exactly happened at this point. We just know that in his bill of particulars, he alleges the total, the permanent loss of use of an arm that is continuing.
Counsel, do you have a problem that you didn't invoke the BP or the complaint below?
I'm sorry?
Did you make that argument below about the BP, what it says in the BP and what it says in the complaint?
So I believe in the opposition we're talking about, we said that the motion was premature because there wasn't sufficient discovery that on the issue of plaintiff's medical condition, that was sufficient, and that was sufficient for the court to deny the motion as premature.
So that's a no.
So that would be a no.
Okay, thank you.
Thank you, counsel.
Your Honors, please, Ed Guardaro for Champion. I'll just follow up on some of the court's questions. Justice Moulton, no, a lot of this stuff wasn't raised. You can look at it, the affidavit in opposition, the amended ones, 152 to 156. It's really like 3 pages. The third-party complaint on 64. But let's get right to the heart of the matter, which I believe Justice Mendez, Justice Singh, we're addressing, and my colleague is relying on. So on the record, the plaintiff was extremely, I'm talking about the bill of particulars of the plaintiff. It's one of the most specific BPs, I've seen. It's a very specific bill of particulars. And
So the language is permanent, that the injuries are permanent and continuing in nature. And your adversary argues that at this stage, at least, that's total.
Right. So if I may, Your Honor, every one of the articulated injuries to all the parts of the body of soft tissue, and on page 88, first paragraph, full paragraph, says all of the foregoing injuries, resulting disabilities, aggravations, exacerbations, and involvements are associated with further soft tissue injury to the areas traumatically affected. It's a plaintiff's very specific BP. Nothing about total loss, nothing about grave injury. As we all know, there's no allegation below by the plaintiff. So the O'Flaherty case, even though it's never been raised before, the specific language, Justice Moulton, you recall, was that in any event, there was specific language in the BP upon which you could make out a grave injury. And that's what one of the many distinctions of O'Flaherty is. Here, if you look at the actual record, if you look at the language of the BP, and it's very specific, I commend my colleague, but it's specifically intended not to make out a grave injury. If you look at it, I mean, all of them say post-traumatic strains, sprains, spasms, range of motion restrictions, swelling and tenderness, post-traumatic arthritis, potential future injections, things of this nature. So Justice Ramseur was looking at this particular bill of particulars in addition to everything else. And I believe Justice Manchu was right in the determination that just no grave injury is here. That this court has, for years and years and years, and I know my adversary talks about the general rules, but for years and years, this court has used this terminology, and I'd just like to invoke it now. Rank speculation is no substitute for evidentiary proof in admissible form that is required to establish an issue of fact. That goes back to Tung Soo Pong versus Bronx, Lebanon, 213, 82nd, 236 in 1994. I believe it's applicable here. Thank you, Your Honor.
Thank you, counsel.
Your Honors, just quickly on page 88 of the record, it very clearly does say that there was a loss of use of the above-mentioned parts, which included the arm that is permanent and continuing in nature, so I'll say that. And also, the standard here is very, very low. It's just if the alleged injury could in any way be considered a grave injury as per the statute. And unless there's any other questions, thank you, Your Honors.
Thank you. Thank you both. Fox. Take your time.
Claire Liebersol, Molad Spitz, and DeSantis for appellants Barossa Auto Corp. And Daniel Almonte. Good almost evening, Your Honors. May it please the court. This case involves an appeal of the partial subject matter of which I think Your Honors, or at least this court in general, is intimately familiar with, both from the record, of course, but also from the many park insurance company appeals that have been before this court over the last several years. So I want to get right to the heart of it. In the lower court's decision, the actual decision itself is, I think, a veritable roadmap to get you where you want to go. The court refers to, the first order that the court refers to is, and I would ask that the court take judicial notice of this order. It was errantly referred to in the brief by a NYCHA site, and it was not attached as an actual order. So, and this is starting on page 5 of the record. In the order, in the second sentence of the order, it says that this motion is based on the prior decision and order dated December 7th, 2020. That decision placed the stay of this case as of the Judge Hagler order of 9/22/2020.
Well, let's just track it to be clear here. The note of issue was filed by plaintiff on 9/24/2020. You don't dispute that there was anything wrong with the filing of the note of issue, correct?
Well, that is a big part of.
So let's start there. Was that properly filed?
That was not properly filed.
Why?
Because it violated the PC order of your colleague, Justice Higgett, and all the policies and the practices of Bronx County, which is that before you file the note of issue, number one, all discovery needs to be complete. Number two, you need the court order from the IAS part. And number three, your certificate of readiness can't be blatantly false. So the note itself can't be blatantly false. So party depositions were not complete. Now, I want to draw the court's attention on this party deposition issue.
Well, when did you actually move to vacate the note of issue?
We moved to vacate the note of issue on, it was 7 days after the conference of 11/29/23.
So let's go back. See, what I don't understand, can I just ask you this?
Of course.
Why did you wait that long? Because the liquidation stay, based on what you're saying, liquidation stay was lifted by one of our colleagues from 9/24 to 9/30, correct? So you certainly had sufficient time in that period to move to vacate the stay.
Well, that was not how we read the interim stay order of Justice Kennedy. Justice Kennedy lifted the litigation tasks provisions, paragraph 7 and 8 of Judge Hagler's order, but provision number 6 was still in place, and that restricted park insureds from wasting any of park's assets. And also provision 12 was still in place. Provision 12 of Judge Hagler's order had us already in the process of turning over our files to the Liquidation Bureau. So we were in no position to assume that we had any right, authority under the Hagler order and the interim stay order to do anything, even make a phone call. I mean, we were still under the stay.
Even if we go from the date where you contend that the stay was lifted, wasn't the motion still untimely?
The motion, our argument in terms of our motion is that it was timely based on learning that the lower court never treated the note of issue as a nullity. We were under the assumption at all times that the stay was in place as of 9/22. The note was filed as of 9/24. The note was filed impermissibly under all of the policies and the practices and the orders that were.
But that doesn't make it a nullity. It just means that it was filed and it gave you a good basis to file a motion to vacate it.
Correct. And agreed. However, we were still operating under the assumption at all times, don't do anything. I mean, that was the impression. This order has come down. This litigation has been going on for quite some time. We were already of the mindset, and I know I only have a couple of minutes left, so.
So you move, I guess, on October 24th to strike. But by that time, more than 20 days have passed, correct?
Well.
Just if we use that date, if we use your date of October 24th.
We moved to vacate within 38 days of October 26th.
38 days, okay. What's the rule? 20 days?
Right,
the rule 20 days? So your entire argument then is predicated on the concept that the initial filing of the note of issue was a nullity.
It was illegal.
Without that, because you concede you were untimely if the note of issue was properly filed.
Understood. But not only if it was properly filed, but under all of the other orders. Now, the order of Judge Hummel, which I asked again that your honors take judicial notice of, and again, I apologize for that, places the stay, her stay order of 12/7/2020, places the stay as per Judge Hagler's order. Doesn't say anything about the interim stay orders. And again, I argue that the interim stay order had no effect on what we were permitted to do.
Okay. Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Daniel Niger, on behalf of the respondent. May it please the court. Respondent's filing of her note of issue was not a legal nullity. The lower court correctly calculated that both the motion to strike and respondent's note of issue and the motion for summary judgment were untimely. With respect to the motion to strike, the respondent properly filed her note of issue on September 24th, 2020, during a pause of the initial stay of litigation, as Justice Kennedy had granted an interim order of the liquidation stay, but for paragraphs 6 and 12. The note of issue was accepted by the court, and on the same day.
What about the counsel's point that essentially wouldn't go as far as saying that it was perjurous, but discovery wasn't complete, it was just a sham?
Discovery was complete in our opinion, Your Honor.
Were all the depositions held?
The deposition that was not held was for Defendant Burgos, who was not available. Defendant was unable to find their defendant at the time, and he was unable to be produced for his deposition at the time. Also, Justice Goldborn's order didn't address any of the discovery-related issues at the time, but it wasn't a legal nullity that we had filed our note of issue, and defendants or appellants operated at their own peril in failing to file their motion to strike plaintiffs or respondent's note of issue at the time. And
how do you respond to the argument that it was the view of the other carrier that in effect there was a stay and they really couldn't do anything?
I would say that there was an interim period between the first filing of the liquidation order and then Justice Kennedy's initial filing of the interim order that lifted the stay temporarily for those 6 days before Justice...
9/24 to 9/30, essentially, is what you're saying.
That's correct, Your Honor. That interim period is when the note of issue was filed properly. And from that date, after the lifting of all of the liquidation stays and the lower court stays, the motions that appellants filed in this case were both untimely. 40 days past the lifting of the stay for the notice, the
I
motion
think
to
your
strike.
adversary conceded that point. So it's really, the basis of the argument is that the note of issue was filed improperly or impermissibly.
I'm sorry, that the note of issue
Saying
was...
that your adversary concedes the point, if we look from the latter dates, they're late, but her argument is that your note of issue was filed improperly initially.
Understood, yes, that's correct. I would just go on further to say that if the stay had been in place at the time that the note of issue was filed, the Supreme Court would have rejected the filing of the note of issue. So the failure for the court to reject that filing is proof that it was timely filed in and of itself. I would say also that appellants also cannot have been said to have encountered unusual or unanticipated circumstances, as they were the ones that informed the court of the lifting of the stay. Furthermore, with respect to the summary judgment side of the motion, the Justice Hummel's part rules also highlighted that they have to be made within 60 days, and appellant's motion for summary judgment was made actually 80 days after the lifting of
I
the
think
stay.
we understand your arguments, counsel.
Thank you, Your Honor.
I think what my adversary is trying to say is that the note was valid because co-defendant couldn't find the witness. I don't find that that's a valid basis for filing a note where the IME was also outstanding, paper discovery was also outstanding, and we never had the benefit.
Yeah, but I
phone
understand
call.
that. But your adversary's point also is that you had a period of time that you could have protected yourself by moving to vacate the note of issue for all the reasons you're saying. That 6-day period.
I dispute that, Your Honor. As I stated earlier, our position is that we were still operating under the stay order, and I will leave that for this court to interpret what you meant by the interim order.
So how did you find out about the stay? About the stay being lifted?
Well, I don't know that I was privy to. Are you talking about the interim stay order?
For Justice Kennedy.
Just the stay in general?
No, the
Judge Hagler's order?
The 10/24/22 lifting of the stay. How did you find out?
The docket.
The docket.
On 10/26.
On
when
10/26.
it was uploaded on 10/26.
So at that time you knew that the stay had been lifted.
Correct. And there was a conference set for 11/29/2023. And at that time, and although this is not in the record, if you would forgive me for mentioning this, at that time, Justice Hummel's pretrial settlement conference part rules, because it was still around the time of the pandemic, involved also conferencing the cases for any discovery issues. Because you have to understand that this all happened in the context of COVID. And so even from the standpoint of the gubernatorial COVID tolling orders, Judge Goldberg gets it wrong.
Granted, but what did you do in terms of vacating that note of issue between 10/26 and November 29?
We had no understanding, and we didn't accept the fact that the note was viable in the first place.
Okay, but
So there was no
So
motion.
granted you don't.
But what do you do? Even though you believe it's a nullity, they file a note of issue. What do you do to protect yourself?
There was no, I mean, we were obviously, based on your Honor's question, you're implying that we were operating under a misapprehension of what it means when you file a note as against a statutory stay. We were operating under the impression that that is, in and of itself, a legal nullity, should have been voided ab initio. And we expected that once we got into that conference with Judge Hummel.
So you assumed that it would be vacated by Judge Hummel.
Not even necessarily vacant, just deemed a legal nullity.
Okay, and now you get before her, and what happens?
We make the motion.
And she denies it.
Actually, she informed us, I'm going to give you leave to make the motion, but I have to send you to the trial part because there's new court rules post-pandemic that were pushing old cases to trial, even though this case had only been under litigation for a year. And I would add that I was aggressively litigating this case for a year. Justice Higgett probably knows.
Thank you, counsel. Thank
Okay.
you.
Thank you, Your Honor.
Thank you all.
It was an honor to argue before you for my first time.
Well, our pleasure.
Have a good evening.
Sakaya? Did I butcher the name?
I'm sorry, Your Honor?
Did I butcher your the client's name?
I'm Lauren Bryant for the plaintiff appellant, Ms. Scaccia. And may it please the court, we are asking that this court reverse the award of summary judgment to the defendants in this case. As a preliminary matter, Your Honor, we contend that the lower court erred in finding that the plaintiff slipped on what it deemed an inherent slipperiness of the floor, and that plaintiff's testimony regarding the foreign substance that she slipped on was speculative at best. This court should be guided by an almost identical set of facts in its holding in De Paris, which was a case that recently came down.
How is it similar?
It's similar in these ways, Your Honors. In De Paris, the plaintiff slipped in a bathroom. In De Paris, the plaintiff looked down, saw the indent of her shoe on the wax in the floor. And in De Paris, the defendants testified, well, we don't ever wax the bathroom floor. The lower court in that case held exactly as the lower court in this case did.
Oh, in Paris, she saw a big line.
Yes.
The dent in my shoe in the wax all the way that I felt, and we suggested that that goes to some sort of negligent application. What is it about this case that's similar to Paris?
Your Honors, if you look on pages 180 and 181 of the record, we have plaintiff's testimony. And I'm going to skip over a few lines here. So they ask her, after you got up, did you look down at the area where you fell? She says, yes, I noticed there was some sort of waxy, sticky stuff on the floor. It looked like it was sort of, I'm saying what she said, it looked like it was sort of like, you know, buffed. And I know that because it was all on the side of my clothing. I noticed where I fell, the indentation on the floor into the substance of what was on the floor.
So you're saying that's the negligent application of the substance, if it's whether it's wax or some other substance?
Yes, Your Honor, because
and who's the party? Which party would be responsible for that if we were to agree with you?
There's a tribal issue of fact here as to which defendant may have created this substance. We have testimony as well as the evidence contained in the agreements, the maintenance agreements from both parties, that they both were responsible for waxing and buffing the floors. If we look on page, I believe it's 435 of the
wasn't
of the record.
My understanding was that it was Harvard was responsible for cleaning and polishing
So,
the
Your
lobby
Honors,
floor.
This is another similarity to De Paris, where Gino Ortero for ABM contended that they do wax and buff the upper floors, but that they never wax, ABM never waxes and buff the lobby. However, if Your Honors look at page 439 of the record, it specifically says that ABM is responsible. This is all the way down 3 parts up. All hard surface floors will be machine buffed. And so this is, again, a triable issue of fact with respect to what Ms. Otero is claiming and what the contract.
So it's your position that both defendants fall under the Espinal exception?
Yes, Your Honor, yes, and that there's a credibility issue here. There's multiple triable issues of fact here for a jury to determine. Now that we've established that the
let's return to the word indentation.
Yes, Your Honor.
What does that mean here?
I'm sorry, can you be a little bit, I'm not really sure what is the word indentation?
She fell to the floor, and the testimony is that somehow there was an indentation.
Yes.
What does that mean?
So basically, I think what the plaintiff is saying here is that there's an indentation of where she steps, because, and I'm not sure if Your Honor's had a chance to review.
It's a word that seems a little more vague to me than the words used in Paris about a heel that actually makes a mark in whatever surface was there in Paris. So indentation, I don't know, again, it seems a little more vague. So, and it's not unpacked at record 180 or 181. It just stops at indentation. So is that enough?
I think if we look at the totality of the plaintiff's testimony, Your Honors, we have a lot of evidence here that's similar to De Paris. We don't have to hang our hats on the word indentation, although that is certainly a huge similarity here. We have the plaintiff look down after her accident, and she sees a waxy substance on the floor. We see that the plaintiff notices an indentation in the floor. I'm going to infer that means that that's where she stepped with her foot, an indentation on the floor like in De Paris. She notices that the wax on the floor looks like it had been buffed, consistent with what ABM and Harvard are responsible for doing at the premises.
Counsel, how do you deal with the fact of what's on the video where she gets up relatively quickly, a security guard comes over and seems to look at the floor and sort of make gesture that there's nothing there?
So 2 points to that question, Your Honor. First, if we look at the video, we actually see the plaintiff indicate with her foot, which appears that again, I can only speculate because the video is so grainy, there's no noise to the video, but that she is indicating with her foot that something is over that area. And even though we have testimony from ABM saying that they didn't see anything on the floor, this is very similar to DeParis, where the defendant said she went in after the plaintiff fell and she didn't see anything on the floor either. So I think that when we look at the factual similarities to DeParis, the court must stand by that holding.
And what about the number of people that may have traversed that area prior to your client?
Your Honor, I don't think that that warrants summary judgment here. Plenty of people can step in the same area where there may have been a dangerous condition, but it only takes one person to slip and fall on it for that to be a dangerous condition.
But we have hours of people walking by that same spot, and no one falling, no one having any type of incident.
And it may be that everybody else got lucky. Perhaps nobody else stepped in the exact spot where the wax was left. Perhaps it was, the way that the plaintiff stepped into the wax. But again, this is all sort of speculation that's for a jury to decide.
Oh, yeah, that's what I was going to say. Is that really for us to decide, or is that an argument to be raised by the defendants if this case goes to trial?
Absolutely,
and for the jury to decide?
Yes, this is exactly one of a myriad tribal issues of fact for a jury to decide as opposed on summary judgment.
Okay, thank you, counsel.
Thank you.
Good afternoon, Your Honors. My name is Daniel O'Connell for the defendant ABM and Brookfield. And so I urge this panel to consider the totality of circumstances and the numerous and various ways plaintiff vaguely described that it looked buff, it looked sticky.
Well, I'm not impressed by buffing and stickiness because that's not sufficient. The question is what do we make of the testimony of plaintiff saying that I noticed where I fell the indentation on the floor into the substance of what was on the floor, suggesting that there was a lot of some substance which created and some sort of indentation.
And there was something on her clothing.
So that. My answer to that question is this case is a lot more like the case of Hamilton versus National Amusements, Inc., of which I believe Justice Moulton sat on that panel. And there, the only way that the plaintiff surmised that the substance that had caused her injuries is because it was on her shoe and her clothes.
But here she says more. She says there's an indentation.
Yes, but she says less. And she says it far more vaguely than the plaintiff did in the Paris case, which was my shoe made a dent into the substance on the floor. Here we have at page 180 two interesting things, and I'll get to your point first. One, I noticed where I fell the indentation on the floor into the substance of what was on the floor. I don't know what that means, and that is not specific. There is nothing to suggest. Did she fall on her backside? Did she fall forward? It's only a guess that her foot made an indentation into a substance, did not make a big line in the floor, right? Like the case that we were just discussing. And I just for context, I'd like to mention then when asked how she fell, the plaintiff said that she fell and her legs went over her head, like that she fell backwards.
Well, she said she fell to the left and then her legs went up in the air.
Over her head. That's the testimony. I can read it and quote you the page.
Well, there's a videotape, right?
Doesn't show it. Over my head. I fell. The next thing I knew, my feet were over my head, which is page 485. The interesting thing about the quoted language on page 180, right above the indentation argument, it's the inference that she draws very similarly to the way the plaintiff draws the inference in Hamilton. She says, I noticed that there was some sticky, sort of waxy stuff on the floor. It looked like it was sort of, like buffed. And I know that because it was all on the side of my clothing. It's the exact sort of surmise that was rejected by the court in National Amusements. I also would like to make note really briefly on the Espinal argument that I don't believe that Espinal 1 is is in dispute. I believe that Espinal 2, the speculative nature is covered by my previous colloquy. But the third point is whether or not ABM, at least, displaced entirely the owner's duty. And I submit that it is not logically possible to displace entirely.
Well, how about, I guess there's some question as to what exactly ABM was doing, whether they were machine buffing floors. But let's just assume, for argument's sake, that they were machine buffing floors. Would the first exception, launch a force of harm, be applicable?
No, buffing floors does not mean the application of wax per se. And there is no testimony. In fact, it's contrary to wax was not used, nor was so-called marble restorer used. That is the testimony of one of Harvard's employees. It's several different places.
So it's your position that Harvard worked on the lobby floors, correct?
Did not use wax or marble restorer on lobby floors, which is consistent with ABM's policies. And the fact that they had to buff or use a machine on all surfaces, it could have been in the lobby, but that does not mean there was an application of wax. And the only way that the plaintiff gets there is to use an expert, Mr. Moskowitz, who relies only and parrots only the assumptions made by plaintiff. No independent research, no testing regarding coefficients of friction, and most importantly, never visits the premises.
Thank you, counsel.
Good afternoon, Your Honors. John Brennan from Ryan Brennan and Donnelly, LLP, for the defendant, respondent, Harvard Maintenance, Inc. In brief, just our client, there's no evidence affirmatively that our client even worked at this location where the plaintiff alleges she slipped and fell on the evening before. They would do work in sections in the area of the lobby. We're not disputing that we were in the building on the evening before, but we would have been out of the building no later than 6 in the morning, about 8 hours before the accident happens, and who knows how many different people, how many numbers of people up and down that area where she claims she fell. So we start with, there's no affirmative proof that we actually did work at the site where she had her accident. So it would be speculation on that front for us to be held in here on this case.
You did at some point work in this, I mean, because you did the whole floor and the lobby, right?
Your Honor, correct in that
and
our
that's
job.
You say in your brief that's, I think, maybe not correct statement of the law about the first Espinal factor, that you had to be like working the day of almost. You made it sound like to launch an instrument of harm. And that, I don't think, is the case. I mean, you could have done something negligently, I'm not saying it has happened, several days prior to her fall, and that would be sufficient to launch an instrument of harm. Am I missing something in your argument?
No, Your Honor's correct. I might have overstated that in my brief in terms of, you know, it's not that you have to necessarily be working or ongoing at the time. If you did present an issue or created a condition that was an instrument that launched harm, you would be held responsible for that. But again, to the point that there's no evidence of us actually affirmatively working at that location. And then even if we were gone 8 hours before. And the fact is, hundreds of people walking through that area. And the fact is that you have a security guard come over to the site, look at it, check it, and see there's nothing on the floor. You have multiple people walking through this area before.
Counsel, I understand that's what the security guard, that's the position, but the plaintiff's position is somewhat different, and you certainly don't want us to be weighing evidence to make those determinations, right?
In other words, you make out a prima facie case for summary judgment, and then they raise an issue of fact.
We would submit that the lower court was correct. There was not sufficient evidence to raise a question of fact with respect to our client, Harvard Maintenance. We were an Espinal defendant. We weren't launching anything that created an instrument of harm.
So
she was not relying on us.
She says that when she fell, she noticed an indentation.
her testimony or description is as vague as it can be. She talks about generalities and things like that. She doesn't talk about having anything on her shoe and actually going through there. She doesn't have that. She talks about allegedly seeing something there, but she's vague. She can't, there's no color to it. There's no color. She has no color. And then again, very...
Counsel, you say that if you had worked in the area, you were gone 8 hours before the accident, correct?
We would have been gone 8 hours before the
But
accident,
doesn't the
Your Honor.
contract call for 24 hours of letting the marble floor dry? So if you were there, doesn't your contract call for that?
There's language in the contract regarding 24 hours, okay, Your Honor, in terms of the location and what we would do. That type of work would not, I think that would be different in terms of that work. It wouldn't be that work that was being done at the time. But with regards to specifically this location, after we do our work, you have ABM come and look at it and make sure that it's properly done. And that if there was an issue, they would have reported that to us. There was no complaint. There was no suggestion at all that anything we did was improper, and the testimony is clear from ABM's own witnesses that Harvard didn't do anything wrong here. They didn't make any complaints to us about anything. The testimony is clear. There's no complaints about that floor on that day. The records were searched. There's an affidavit confirming there was no complaints about that area of the floor. And I don't think, I think it's crystal clear. The video shows people affirmatively walking right through this location where plaintiff claims she fell. And there's no slip. There's no fall. If this was a dangerous condition, multiple people would have been falling at that location. There's no evidence in Paris, I believe. There's no video showing the incident. There's just testimony. In this case, you have a video that's affirmative proof that there was no dangerous condition at the location. And the affirmative proof is multiple people walking through that location before, without incident, multiple people walking through that area after the incident, without incident.
Thank you, counsel.
Thank you very much.
Briefly on rebuttal, Your Honor, so I just want to go back to plaintiff's testimony. When we look at her testimony, she describes what the wax looked like. She describes an indentation in the wax. She describes that the wax was on her clothes and that she could feel it on the side of her clothes when she got up. If all of that isn't specific enough to at least raise a triable issue of fact, then what chance does any plaintiff stand of rebutting a summary judgment motion? Are we going to put the onus respectfully on plaintiffs to smell the dangerous condition, to identify the exact size down to the inches of the dangerous condition, the color? I mean, on summary judgment, this is really a question for the jury. With respect to Espinal, I believe Your Honor's already addressed this, but yes, we are referencing the launching of force or an instrument of harm vis-a-vis creating the dangerous condition by negligently waxing and buffing and or failing to remove the wax from the floor.
And with respect to ABM, what's the basis to say that they launched the instrument of harm?
There's a tribal issue of fact here, Your Honor, as to whether or not ABM had some waxing and buffing responsibilities with respect to the lobby vis-a-vis page 439 of the record, which is the contract that requires...
Other than the contract, is there anything that puts them on the lobby floor in the area of the incident?
Your Honor, not on the record. However, as the summary judgment movement, it's defendant's onus to show us that they were not there. We have no evidence whatsoever of if or when the area was last cleaned, inspected, waxed, buffed, what have you, prior to the accident. So because that's on the defendant in summary judgment movement, it should have been denied.
Thank you, counsel.
Thank you.
Thank you both.